There are only one who considers that. Just for the
For motion, item number 1.
May I please, Your Lordship?
Yes.
Lordship, this is an application under Article 226 of the Constitution of India for issuance of a writ in the nature of habeas corpus with a direction to set aside and quash the impugned order of detention dated 35 of 2024, issued by respondent number 2.
Will issue notice?
Yes, Your Lordship.
Mr. Tiwapong, how long will it take to get instructions?
2 weeks, my lord.
2 weeks.
Yes.
Your good name?
Thea Krula.
Heard Ms. Thea Krille, learned counsel for the petitioner, who submits that by filing this writ petition under Article 226 of the Constitution of India, the petitioner prays for issuance of a writ in the nature of habeas corpus to set aside the order of detention dated 30/5/2024, passed by the Special Secretary to the Government of Nagaland Home Department, detaining the detainee under Section 3(1) of the PIT and NPS Act 1988. Stop. She therefore submits that the same should be set aside in view of the fact that the detainee is innocent. Next para. In terms of the last court's order dated 14/8/2024, the petitioner has filed an additional affidavit on 29/8/2024, enclosing a copy of the impugned detention order dated 30/5/2024. Next para. Upon perusal of the materials available on the court and upon hearing the counsel for the petitioner, said no honorable by 2 weeks. Mr. E. Tiwapong, learned public prosecutor, accepts notice
For all the
on behalf
respondents.
of all the respondents. As such, no formal notice is required. Petitioner shall, however, furnish requisite extra copies of the writ petition to the learned PP within 2 days, if not already done. List the matter again after 2 weeks. By the next date, learned public prosecutor shall obtain instructions and also produce the relevant reports.
Okay.
Much obliged. For admission, item number 3.
We'll take up this matter first because the other one might be a bit lengthy.
Yeah, please, your lordship. I'm told the executive director of the NHITSL is personally present. So, my lord, necessary clarification, lordship. Yes.
All right, just a minute.
Betul. Ambil kopi Diana kali lah. Last order. Order rasa tak? Last order. Last here.
Yes.
As
Uh,
well as to the noble
ah.
officer that is the executive engineer as well as the authority engineer, they are here.
Officer is here
Yes.
and
I'm executive director of
You-
NHIDC.
okay, you're the executive director. Okay, what have you to submit regarding the manner in which the construction work has been carried out, and now especially in recent times, the road blockade because of the landslide? How is the work being done?
Sir,
Please tell us.
respected sir. What happened, sir? Last 10 days, about from, I mean, 20, about 10th to 16th, there was continuous rain, 10 to 16. So 16, sir, suddenly the whole mass of that hill has come down because of the point where it has occurred, sir. Yeah, the rock, it is not rock. It is made of soil, and that is black cotton soil, sir. The black cotton soil, what happens, sir? As soon as when it is dry, sir, it is very hard. But when it takes water, saturated, then it goes on sliding. So that has happened, sir. That there is a query going on about from our ROW. Sir, our ROW right of way is only 45 meters, sir. One query is there upstream on a hill is about 500 meter to 600 meter away from us. Ponds there. So those things have, the water is accumulated there, and that has slided, sir, saturated the whole mass, and whole mass has come down, sir, towards valley. And then our road was about 14 meter height, heap was created, and it was all muck, sir. It was not soil. Muck means we were just not able to stand on that. It was going that much when we were standing also, sir. So this heap, sir, we have started removing, sir, on 16th. Because 16th, sir, we got that everything was sprayed. So then we have started, sir, on 16th. So 3 days it took, sir, up to 19. We goes on removing, sir. But what was happening, sir? The muck is always coming from top. So whatever we were removing, sir, again it was coming. So one day we could open it. Then again a muck came and everything was sprayed. And then again we have started last 5 days, sir. We are working there because, sir, last 5 days rain is not there.
You are the director,
Executive director, sir. I'm in charge of Nagaland, sir.
executive director in HIDCL.
Right, sir.
Now, who is executing the work?
Sir, here, sir, this section, sir, this is called package 3, sir. 2 contractors. One is Brand Eagle is there
Brand
for
Eagle.
the road, sir, and Meka Ferry, one contractor is there, sir. They are for the slope stabilization.
Okay. So who is doing the clearing of the debris or the mudslide?
The mudslide is the responsibility of both, sir. Because both, sir. Because both,
Okay.
sir, some part road cleaning has to be done by the Brand Eagle, and some part is there also as per the contract, because that part is given to them to make a ferry. So both together they are working, sir.
So on the ground, Brand Eagle is working
Both, sir. Both.
and Meka Ferry is also working.
Yes.
But this Mecca ferry has come to the picture recently only,
Sir, about 5 days back, they came to picture.
because court was not informed earlier that there was another company who is responsible for maintaining the slopes. So both Brand Eagle and Mecca ferry are on the ground
Right,
working.
yes.
And what is the present situation?
Now, sir, we have 6-meter width, sir,
Hmm.
because it total is 24 meter. 6-meter width, we have made it clear, sir, yesterday, 8 o'clock. So now traffic from Kohima is going to Dimapur. Sir, still its sinking is going on. When traffic is moving, sir, still it is going on. So we are putting boulders and then it is again, every 2 hours, sir, we are repairing it. And then traffic is moving. So yesterday, sir, about 70-80 trucks from Kohima side, empty trucks has moved towards Dimapur side, sir.
Okay.
About 80
Okay.
trucks, night time they have moved.
And the clearing work is still going on. Otherwise-
Clearing work, sir, I think only the repairing of this 6-meter cleared portion, one-way traffic we are allowing, sir.
One-way traffic.
One-way traffic, sir.
So turn by turn they're going.
One by one, sir. Yes,
Okay.
sir.
Now, clearing of the road and the blockade is one thing. But like you said, there are 2 streams or there are some, what do you call, some pond on top of the hill from where the mudslide is coming.
Sir.
So how is the problem going to be addressed?
Sir, here the problem is, sir, not only of NHIDCL, sir, because it is coming beyond our jurisdiction. Because our jurisdiction is 45 meter only, sir, width. And then it is coming from, sir, 500 meter. So a state has to take that call, sir. We have written to a state also, sir, that they have to take call. Because, sir, our jurisdiction we can take, sir. We cannot take
No, correct. But you're taking up the matter with whom in the state?
to the secretary, commissioner, sir, of works. Secretary works.
Okay, when was this taken up?
26th, I have written letter to them also
26th of this month.
of this month,
That was 3-4 days back.
4 days back.
4 days back.
Sir.
Why not earlier?
Sir, earlier also we were writing, sir, and we were saying also, earlier, sir, also letters are there, sir. We have, but sir, this type of things first time has been identified that it has occurred not due to only NHI, mainly due to that to top hill.
So was there any survey done to find out that there was stream and there was some pond on the top of the hill?
Sir, local survey Mecca ferry went up, sir.
Mecca
And-
ferry went up.
Yes, sir. And they have prepared plan and elevation that how it has happened, sir. So everything is visible. And also state government is agreeing, yes, it is there.
So once the survey and plan, everything is made up, then how is the same to be put into motion?
Sir.
Because your role is for that construction of the road. You say the ROW is for 45 meters. And the slope maintenance is there, of course. But if it's coming beyond the, in and around the road from the top of the hill, what is the plan?
Sir, here we have to work together with the state government, sir, because here the situation is totally different. It is not only NHIDCL part is causing the problem, it is causing the away from that.
Okay. So apart from this stretch of this road near Zubza, is there any other place where this kind of problem is there? For-
Similar problem is not
mudslide.
here, sir. Mudslide has occurred from where it has happened, sir, 2-3 meter away also it has happened, but it was less, sir. It was happening many places, sir. That's why we have identified about 19 locations, 2 and we have given to Mecca Ferry that these places we have to do slope stability so that future I mean, nothing happened.
You have identified how many places?
19 places, sir.
19 places.
Yes, sir. Total Mecca Ferry is given, sorry, 16 places, sir.
16 places.
Yes.
And who is undertaking the work?
Mecca Ferry, sir.
Mecca Ferry,
Mecca Ferry for slope.
for slopes, for all the slopes.
For all these 16 numbers places.
No, this is falling within package number 3
3. Yes,
only.
yes,
So Mecca Ferry is only responsible for package number 3.
sir.
So Brand Eagle is constructing the road for package number 3. Mecca Ferry is doing the maintenance of the slopes. And apart from this Zubza area, there are other 16 places
Sure.
which has been identified wherein there are mudslides, but not to that severe extent like this one in
Sure.
Zubza. So that is what you are saying. And on 26th, you have written to the state.
26th, there was meeting with Chief Secretary, sir. And in that also I have told, and I have given in writing also, that, sir, this landslide, this recent landslide where we are facing problem has caused due to the query going on, and also pond is made there. All those things have triggered this massive landslide.
You said you have written also
I have written, sir.
on same day, 26th.
26th.
Meeting was there, you have written also.
Yes.
So probably roughly that would be the issue regarding package 3. Now, another concern is regarding to package 1,
Sir.
near that
Pagla
that
Pahar.
place called
Pagla
Pagla Pahar. There are frequent rock falls and casualties there, damages are there. How are you addressing this issue?
Sir. Sir, casualty happened, sir, in July 23, sir, where some people died also, sir. After that, we have taken this matter, sir. And first, what we have done, sir, it is a 4-laning. So in between, there is a median, sir. So median about 2.5 kilometers, sir. We have put tri-beam so that if rock comes from there also, the second lane is not affected. Because first lane, sir, we have closed it for traffic.
No, what do you call it? What
Sir,
beam?
Sir, 4 lane is there, sir. One is up and down.
That we have understood.
Yeah,
That-
it
the
is a
mid-
divider between the two lane.
What have you put on the divider?
Divider, sir, we have put tri-beam, metal crash barrier, sir.
Tri-beam.
Tri-beam. Metal crash barrier it is called, sir. Metal crash barrier.
Metal crush.
Big crash barrier, sir. It is just height, sir. While passing through road, sir, you have seen, sir.
How big and how high is it?
It is about 1.6 meter height, sir. 1.2 to 6 also is there. Top is 6. 1.2 to 1.6 is there, sir.
Okay. So this is called metal crush barrier.
G.
So this will prevent the rocks coming that side.
Sir, what we have done, sir, 5 kilometer Pagla Pahad, 4 lane we are not allowing to move, sir.
5 kilometers.
5 kilometer. Only 2 lane traffic is moving, sir. This is because the rock is coming mostly in that side lane, hillside lane, sir. So that side lane we have closed for the traffic 5 kilometer till we do our work. So here, sir, what we have done, sir, this is just a measure, sir. It is not a permanent solution. For the permanent solution, sir, we have engaged a contractor, sir. They are doing the work. But, sir, what is happening, sir? The rock is there, sir. Overhanging rocks is there.
Who is the contractor?
The contractor is innovative, sir. Innovative. I think their people are here, sir.
Yes.
So, sir, actually, there one item could not be executed, sir. The sloping, sir, there is a rock, sir. And rock also, it is just coming up. So, we are just putting with chisel and then making it out so that it does not come out automatically. Otherwise, sir, there will be accident. So, this, sir, the quantity was 6,000 cubic meter. Only 1,500 was executed, sir, because we have to close the traffic for this activity, sir. Otherwise, sir, because when chisels and they will break it, sir, it will come on the vehicle, sir. So we are requested district magistrate, sir, and district magistrate is telling that they will give 3 hours in one day, every day 3 hours. But also that also could not materialize, sir. So this work also we could not complete.
That's 16,000.
6,000, sir.
6,000
Sir.
of rocks to be extracted.
Rock to be chiseled itself in shape so that it overburden, sir. Overburden.
6,000 what?
Cubic meter, sir. Out of this, sir, 1,500 is completed, sir. 4,500 is remaining. The completion of this, sir, needs closure of 4 lanes, sir. All because otherwise, sir, there will be accident.
Excuse me. See, what you're trying to say is that because of that slope, which for which the rock used to fall frequently.
Yes, sir.
So that
Rock we are taking
rock
out.
which is likely to fall,
Overhanging rocks, we are
you're
cutting
taking it out.
and taking out.
And you've taken out 15,000, 1,500
1,500 is already
cubic
done.
meter out of 6,000
Sir,
cubic meters.
sir.
6,000 cubic meters will cover that entire 5-kilometer stretch.
Yes. Apart from that, sir, additional work, this is the one, sir, I'm telling you, sir.
Hmm.
This is the one work. Second, I have already invited a tender, sir. Tender is received. That is about 14 crore rupees is there. So 3 bidder has come, sir. We are evaluating.
The tender for what?
Tender for, sir, this work is, sir, this rock fall, because rock is falling, sir, will put net. Barrier will be there, sir. And if rock fail also, barrier will take energy of that and it will remain like that. We will put hole, sir, in that rock. And suppose it coming down, then it will be standing there only. It will not come on the road.
Barrier is in the divider, isn't it?
No, sir. Barrier will put a hole in the rock hill, and there, suppose rock is coming, that will be standing there. It will not come down.
Okay.
That is, that also we have invited the tender, sir, and that also we are doing, sir.
This extracting these rocks is done by whom?
By innovative, sir.
Innovative.
Yes, sir.
They are responsible for that, along with the construction of the road.
No, sir. They are given only this this metal crush barrier and this overhanging removal. That work only they have.
Okay, metal crush barrier. And what do you call that work called? That extracting rocks, what do you call it?
Extracting rock, we are calling, sir, overhang removal of overhang removal.
Overhang removal.
Removal of rock.
Okay. So when will the entire 6,000 cubic meters of rock be extracted?
Sir, as per, suppose, sir, they give only 3 hours per day because, sir, whole traffic has to be closed. So then it will take, sir, 80 hours. Means, sir, if you have to go on regular also, so 30 days means it will be 90, 30 into 3, 90 hours. 1 month it will take. If regularly 3 hours is given, then 80 hours it will take total, means 1 month. If 3 hours per day they give us.
80 hours will be required.
Total 80 hours will be required, sir.
And what is the timing? The 3
Timing,
hours?
sir, they have told that they will mobilize their team, if allowed, in 5 days. Because team has gone, team they will mobilize again.
No, the timing for that 3 hours is not given till now, is it?
No, not given, because
Not given.
district magistrate has to allow that, and they have to give timing when they will allow us.
Okay. Now, going back to that package 3 again,
Yes, sir.
you were saying that the road is almost sinking.
Yes, sir.
So what remedial steps have been taken?
That, sir, we will inquire, sir. Today I'm not able to tell the perfectly that what is has gone. Actually, sir, what has gone wrong, sir? It is the road. The situation has gone below that, sir. So what is everything has gone towards the hill, about 20 meters. Everything has slided down. Even our road has slided down. So now we have to call makeup ferry and other things will sit, sir, and we have to find some testing will be also required. So then only we'll be able to take final that what exactly we have to make that road, sir, but we will make it.
So that means that not only the overhead stream, the pond, which is causing the mudslide, has to be taken into consideration, but also what is below the road also, isn't it?
And below is hill, sir.
Correct.
Because everything is sliding
So-
like this.
the entire area in and around the road, above and below,
Sir,
will have to be surveyed.
yes, yes,
How to go about it?
yes, sir.
Unless you have some retainers below the road, whatever is there as of today, again it will slide.
Sir, that's
Even
why,
if the rock doesn't fall or even the mud doesn't slide,
sir,
whatever is there with the movement of vehicles, it will keep on sliding.
it is sliding, sir.
So
Already
that's
sliding.
why remedial steps have to be taken below the road as well as above the road.
Yes.
And
Sir,
for
but
that-
above, sir, a state government also to be given, sir, because 500 meter away, sir, we cannot work, sir. It is a very costly affair, sir. So at least, sir, they should do whatever beyond our ROW. And then we will see that our ROW is safe.
Correct. See, everybody has to work together.
Yes.
You have your work of construction of this road, maintenance and all that. But then in and around to make things conducive, if it goes beyond what is the construction site, then of course, other factors are also there. State will have to also look into it. Yes, Mr. Takama, sir.
Lordship, today we are trying to file a solution as and when we file the deal affidavit and only with the other issue, all the relevant issues can be highlighted. But as on today, Lordship, as pointed out, beyond the right of way above the road, my lord, unless and until the state comes to the picture with regard to what is there above the road beyond ROW. So, my lord, the chief secretary, the state government should be also directed to file an affidavit on what kind of a steps they are going to take. And the respondent, all the respondents may be file a detailed affidavit on the steps to be taken. What steps they are going to take. But immediately the concern is to ensure that the road is maintained.
Correct.
So, my lord, by this morning, the officers are in a better position to know, but because of, I'm told the mud could be about 5-6 meters, feet deep. So it's for a small vehicle to ply, because after the big vehicles, all the big vehicles are plying there. So unless and until the it is properly maintained by putting rocks, it may be difficult. So that aspect has to be taken into consideration at the moment to ensure that the road, if there's a single road is maintained in pliable for all vehicles, not only the heavy vehicle, but the small vehicles too.
Correct.
And for the Rockfall, Lordship, in spite of the metal press barrier that they have bought, still, even in the month of August, I'm told there were some vehicle damages because rocks are flying above that. So in this is an issue of serious concern. In fact, as in when the affidavit is filed, I'll point out the defects earlier, the technical defects earlier. I'm not highlighting anything today because it is only for interim measures today. But Lordship, now the concern is to give direction to the deputy commissioners in the state. I think it should be Deputy Commissioner Chumukitima, District Magistrate Chumukitima in the state government, for closure of the area so that the company will work, and to ensure that the alternative route is properly maintained by the state. Because there is an alternative road when that area is closed, but to what extent, whether it is properly maintained or not, this is a recurring issue every year.
Correct. The alternative road has to be maintained.
Yes.
But you're saying closure of the road. What does it mean?
Because, my lord, the district magistrate, unless should give necessary, and earlier occasion also those directions were given by this honorable court, the district magistrate should be given, should ensure that pass necessary order and inform the public that for a certain specific period of hours, every day or every weekend, whatever, the road should be, that portion should be closed. And
Mr. Takamasa,
yes.
see, before we start giving directions, perhaps we should also call for the report from that district magistrate. What steps have been taken?
Lordship, yes.
Isn't it? Because they know.
I have no objection, Lordship, for that.
This is their job. They know
Yes.
what is to be done.
Yes.
So before we start instructing them what to
Lordship,
do,
fine.
let
Lordship,
them come up with
Lordship,
what
fine.
steps they have taken.
Lord- But,
If that is not sufficient, definitely will,
but the issue is my lord, the issue is of public importance. There is an urgency here. So my lord, the only concern is that if proper division bench is not constituted, then again, it will prolong for quite some time. That is the only concern. So my lord, take down
Yes.
into consideration, the district magistrate may be directed what steps they have taken to be reported before the Honorable Court in the meantime to take appropriate steps.
yes. So, Mr. Executive Director, what's your good name?
Sir, myself, sir, RP Singh.
RP Singh. Okay. You have appointed, what do you call
To assist the court, sir, I have been appointed.
no. Supreme Court has also given some direction regarding appointment of a nodal officer.
I am,
You are the nodal officer, I see. So you have made some submissions today. We would like that to be in the form of an affidavit. How soon can you file it?
2 weeks. Thanks.
Because,
Yesterday, Lord, the
the-
other day, 2 weeks time was given, Lord.
Ah.
On Wednesday.
time was already given
Yes.
otherwise, isn't it?
Yes.
So there's an order already passed on 28/8, and pursuant to which you have come here today also to assist the court. Yes, Mr. Muad, in team, so
Your Lordship, as per the direction of the last 20th of this month, state respondent that is involving the district administration, district disaster management, we have ready to submit that action taken report till yesterday, that is 2029. So I mean, allowed to place the report.
no, you have the report.
Yes, yes. Not in the form of affidavit.
Let him file an affidavit,
I think
Lordship.
it should be filed so that it
Yes.
remains in the record
Otherwise,
appropriately, isn't it?
Regarding as pointed out by the Ireland amicus curiae in the last hearing, that to mitigate that landslide, there should be a drainage top of the hill. So there's also, everything is included there.
Mala,
So
let him
we-
file
we-
an affidavit.
Yeah, we have planned to work out everything involving geology and mining also.
All right, you file it.
Lordship, my only prayer at this moment, since they have already worked out the plan of action, they should not wait for they should not wait for filing of the affidavit to implement their plan of action. So direction, Lordship may be given to immediately implement the plan of action by the state government, subject to filing of the affidavit.
Lordship, here, I have given the page number 13. That is the inspection report. The committee was constituted by the district management, disaster management agency. So the page number 13, they have given all those, what has to be done in order to mitigate all those landslide, not only in the present situation, but in the future also. And also, page number 21, that is a observation made by the Geology and Mining Department to mitigate the landslide in and around that present landslide area. So we have checked out all the blood, and it is already started and going to be again materialized in the near future.
Okay, this is a plan, no doubt, but how do you plan to put this into motion?
That is the issue, Lordship.
No, Your Lordship, is already in motion now.
So let us know what steps you have taken. Plan no matter how good it is, unless you put it into motion,
Yes.
we cannot see what is the effect of that. So you'll have to tell us.
Of course, in the report, Your Lordship, admittedly, there's no time factors given. So what's the direction will be given?
Yes, definitely.
work
You-
out.
How you going to check out that, you let us know. Because this court also would like to assist you, to monitor you, how you work out your plans. But
Lordship
this
may,
is-
Lordship may give a direction to immediately start with the implementation of the plan of action.
And on 26th of this month also, we have issued a direction to the NHITC.
Hmm.
That is on the page number 14, page number 14. Direction has been issued.
All right. Okay, we'll pass the order then.
Lordship,
2 weeks' time.
one request,
Hmm.
my lord, in future, because of the importance involved, either the nodal officer or an officer representing him should be made available, should be present in all hearing to go for immediate instruction, as
Correct.
well as to ensure that the authority engineer is also present.
Oh, by the way, where's the authority engineer? Yes, we have not heard you. Mr. Singh, you take your seat. Let us hear the authority engineer.
Yes, Lordship, the progress of the work so far after the appointment of the new contractor.
Yes. What is your good name?
I am Detention, sir.
DK Singh,
Sir.
authority engineer.
So I recently we have mobilized at the location. Only 30 days has been completed.
Hmm.
And out of 10 members team,
Hmm.
only 4 members are available there. And in that, from 16, we are on 164 kilometer for 24 hours. So I have to look after the matters completely.
No, as authority engineer, what is your job?
Our job is to supervise
The work.
authority.
Ah,
Yes, sir.
to supervise the work, the
Yes,
contractors,
Yes, sir, to supervise. the
to
work.
see how they're progressing the work
Yes,
with the work.
yes.
Now, what steps have you taken in this stretch of this package 3?
That's recently we are working for the move,
Clearing the
yes, sir,
debris.
removal the debris.
Hmm.
And instead of that, also for investigation, we are carrying on along with the maker firms.
Lordship, besides the landslide area, since the authority engineer is appointed for the whole project, I would like to know what is the progress of the work in total as on today? Because of contractors who were appointed, I think, 2023, I do not know.
Have we implemented the authority engineer by the last?
Yes,
order?
yes,
Respondent number? Respondent number 17.
Yes. So Lordship, let respondent number 7 also file an affidavit on the next day
Oh, definitely. We'll
to,
require a detailed.
to highlight the progress of the work of the whole project, besides not only the landslide area. What is the contract date? What is the date of contract? When the work order was issued to you? When the work order was issued? Second? 23 September, no? My lord, the work order, I'm told the work order was issued on 23rd of September 2023. I'm yet to receive a copy from the respondents. But if that is so, my lord, it's more than 6-7 months since the contractor has been appointed. So let the authority engineer enlighten this court, how much progress has been, how much percentage work has been completed as of today? Because if we are traveling every day, the progress appears to be very slow. So I would like to know what is the total progress of the work as of today?
Sir.
How much percentage work?
Yes, sir. Physical percentage is 15.88 and financial is 13.86.
18?
We will submit our request in order.
You file 18 physical progress, 18 point
15.88,
15.88, financial
13.86.
13.86.
Only for package.
So, my lord, after the issuance of the work order on 23/9/2023 to Brown Eagle, they have completed progress is 15.88. And financial release is 13.86. So my lord, just 15%, less than 16% done. And if I'm not wrong, the duration is to complete the project by September 25.
Yes.
And in Nagaland, Lordship, the work season is very less because we cannot execute work in, so my lord, unless and until the machineries, everything, manpower is on the ground, the moment the rain stop, they should be in full swing. So my lord, let the authority engineer on the next day, let us know, my lord, how many machineries and manpower is available on the ground from Eagles, from the implementing contractor, so that we'll have an idea whether the machinery is on the ground and the laborers available on the ground is sufficient to execute the project satisfactorily.
Brand Eagle is a party,
Yes, Lordship.
respondent number 15.
Yes. In fact, on 28th, Lordship, I've been directed to file an affidavit. So we'll be filing the affidavit as well as with the progress of the work.
Okay, we'll have the matter in 2 weeks' time. You'll file an
Yes.
affidavit, detailed affidavit of what has been done. Heard, please write down. Heard Mr. Takamasa, learned senior counsel, and amicus curiae in the matter. Also heard Mr. Moa Jamir, learned counsel for respondent numbers 1, 2, 6, and 7. Mr. N. Mozui, learned counsel for respondent number 15. Mr. Joshua Sheki, learned counsel for respondent number 14. And Mr. Imti Imsong, learned additional AG for respondent numbers 3, 4, and 5.
Lordship, I have instruction to appear for respondent number 19.
Mr. T.B. Jamir, learned counsel, submits that he has instructions to appear on behalf of respondent number 19. 19 is,
It's 2 weeks time to file affidavit. Lordship, my power.
that is MS Mega Ferry Infrastructure Private Limited.
No.
Learned Mr. T.B. Jamir submits that he may be given 2 weeks' time to file his power as well as affidavit in the matter. Yes, yes. Next para. In terms of the last court's order dated 28/8/2024, the Executive Director, NHITCL, who is also the nodal-
Nagaland, Lordship.
Huh?
Executive Director, Nagaland, not for whole country.
Executive Director,
Nagaland.
NHITCL Nagaland, who is also the appointed nodal officer. That is Mr. RPC is present before the court to assist the court. Gustav, he submits that in respect of the landslide which has occurred, in chainage 164 under package 3 in Zutza, the NHIDCL and the engaged contractors, that is Brand Eagle and Mega Ferry, are at the ground and making all attempts to clear the road so that traffic can ply. Through the said stretch. To stop the learn, he submits that. In fact, a meeting was held with the Chief Secretary, Government of Nagaland, on 26/8/2024. and that he has also written a letter to the state authority regarding the problems faced for clearing the mudslide. He submits that there are streams and ponds
And stone quarry, Your Lordship.
and also stone quarry high above the road, and for which reason, no matter how much clearance, how much clearance is made, but the mud keeps on sliding. So he submits that the ROW available to the company is only 45 meters, but they are required to work beyond the same in view of the landslide. He submits that the road has been cleared to some extent to enable vehicles pass through the stretch. But at the same time, the road is also sinking, which goes to show that the effect of the landslide is also towards the lower side of the highway, and for which remedial steps will have to be taken. He submits that since the scope of the work, since the work required is beyond the scope of the work, NHIDCL alone will not be able to contain the situation, and that the state authorities also will have to consider lending a helping hand. Next para. He submits that according to the survey done, apart from the landslide in Zubza area, 16 other places have been identified wherein landslides have occurred under package number 3. He submits that Mecca Ferry has been engaged to maintain the slopes within the package number 3, and they are undertaking appropriate steps for maintenance of the road, maintenance of the slope. Next para. On a pointed query from this court as regards the rockfalls under package number 1, particularly in Pagla Bahar area within inverted comma, Mr. R.P. Singh submits that metal crush barriers have been installed within the 5-kilometer stretch, which is approximately at the height of about 1.2 to 1.6 meters high. The same has been installed to prevent the rocks from falling beyond the 2-lane road adjacent to the hillside. He, however, admits that the same is only a temporary measure. And that the company is having other plans to address the situation. He submits that in order to prevent the Rockfall, the company is planning to, is in the process of implementing the overhang removal of rocks, and for which the innovative contractors, innovative construction, is it? Construction company has been engaged. He submits that about 6,000 cubic meters of rocks has to be removed from above the road so as to ensure that rocks do not fall on the road. Until now, only about 1,500 cubic meters have been removed. He submits that since the road will have to be completely blocked for a certain duration to enable the work to be carried out, the permission of the district magistrate, no, that place, district magistrate Chumokadima will be required, and to remove the entire 6,000 cubic meters of rocks, the company would require at least 80 hours of work. Next para. Mr. D.K. Singh, the authority engineer, is also present before the court. And he submits that the work order has been issued to respondent number 15, Brand Eagle, on 23rd September 2023. And so far, the work completed is about 15.88%, is it? Percent. And the, what is that, financial progress is 13.86%. Next para. Mr. Takamasa, learned amicus curiae, submits that. No, we cancel that, not required. We serve that, right? Mr. Imtim Sok, learned additional AG Nagaland, submits that he is ready with the action taken report on the landslide debris blockage in NH 29, Zutza. He submits that a plan has been chalked out to deal with the situation. A detailed plan. He submits that a committee has been set up by the District Disaster Management Authority, Kohima, to study and suggest the actionable points for mitigation of the Zutza landslide at NH 29. And accordingly, a field survey was conducted on 21/8/2024. And the team was also assisted by the volunteers of Jotsoma Village Youth Organization, led by the Additional Deputy Commissioner and CEO DDMA Kohima. He submits that upon such inspection, a report has been prepared along with plans for addressing the landslide. Next para. Mr. Takamasa Lanet amicus curiae submits that in view of the steps said to have been taken by the authorities concerned, it would be better if the same be submitted by way of an affidavit before the court. Stop. He submits that since the state authorities have also prepared an action plan for addressing the landslide, the same should be, they may be directed to put the same into action. He further submits that since the landslide in the highway is a frequent affair, the state respondents also should be directed to maintain the alternate routes which are available so that as and when required, the same can be an alternative for the public to travel between Kohima to Dimapur,
Yes.
vice versa, and vice versa.
Lordship, sorry for intervention. One point my lord, besides the landslide area in Bagala Bahar and package 3, in package 1 and 2 also there are other landslide prone areas. So containing in package 3 in Bagala Bahar, it is quite probable that in those areas also landslide may occur. So my lord, let certain direction be given to the NHIDCL regarding package 1 and 2 to survey and maintain the other prone areas in package 1 and 2 also, besides Bagala Bahar and 164 Chenich and package 3.
Next para. No, same para, you write, the Lanak amicus curiae further submits that apart from package 1 and package 3, it goes without saying that there are many landslides within package 2 as well, which may not be to that severe extent as the one in package 3, but nevertheless, the NHIDCL, Nagaland, not Nagaland, isn't it?
Yes.
NHIDCL should be directed to maintain the road, identify and maintain the road, to make survey, identify and maintain the road. Next para, considering the submissions made today before the court and having regard to the directions, no, okay, submissions made today, the respondent number, nodal officer is respondent number? 16. Respondent number 16. So that's authority engineer.
17 is authority engineer.
Is it so? The nodal officer, Respondent number 16 shall file a detailed affidavit about the steps taken, not only in respect of the landslide in Zutza area, but also in respect of the packages covered by, in respect of the stretch of the road covered by package 1 and package 2 as well. Stop. Respondent number 16 shall also give all the details of the plan for prevention of the rockfall under package 1. Stop. Similarly, the authority engineer, respondent number 17 shall also file an affidavit giving all the details of how the work has been executed, executed having regard to the fact that the construction work is to be completed by September
2025.
2025. The work which has been completed so far appears to be on the lesser side. Stop. Therefore, respondent number 17 shall ensure that the pace of the work is increased so as to meet the timeline. Next para. The learned Mr. Imti himself, learned additional AG, shall also file the action taken report and the plan chalked out by the state administration within a period of 2 weeks from today. It is also made clear that the plan that has been chalked out should be put into motion without waiting for further direction from this court in this regard. To stop, the same will apply to all the other respondents as well.
To the Deputy Commissioner Chumukdima, there are certain directions.
The Deputy Commissioner Chumukdima shall also ensure the regulation of the traffic movement through the landslide area,
My lord, the Rockfall area.
Rockfall.
For that, my lord, certain step has to be taken so that time is given to the company to work.
No, what about this landslide? That falls under
Kohima, lordship, yeah.
Okay, first you write the Deputy Commissioner, what did I say?
Kohima, lordship, let direction go to Kohima.
Is Deputy Commissioner a party in this case?
No, my lord. But my lord, since they are part of the state, Under, since Chief Secretary is there, Lordship. So the concerned officer's subordinate can be directed.
The Deputy Commissioner Kohima should also ensure the regulation of the traffic passing through the landslide area in view of the fact that only a certain portion of the road has been cleared so that no inconvenience is caused to the public traveling through that road.
And Lordship, to provide security if required by the workers on the ground, since they'll be working 24/7.
The Deputy Commissioner Kohima should also
Since we have already provided, I think this question- Security, redundant security. Security is already-
provide it.
Yes.
To ensure, my lord, not direction, but to ensure.
The Deputy Commissioner Kohima should also provide necessary security to the workers on the ground if the same has not been already done.
Yes.
Okay. Then one more line, the Deputy Commissioner Chumukadima shall also work out with the NHIDL authorities for execution of the overhang removal of the rocks by fixing a suitable timing for closure of the road. Which however should be without causing undue inconvenience to the vehicles flying through that road. Next para, the case shall now be listed again after 2 weeks to enable all the parties concerned submit their respective affidavits as directed herein above.
What's going to happen if the personal appearance of the nodal officer takes place for the time being? Since we have already appointed the authority engineer and he's on the site.
My lord,
No, we will request them to be present instead of, see, you may not be available every day, but you can send somebody
yes,
who is well conversant with the matter,
yes.
because all of us are laymen here. You are the expert.
So that observation is made, Lordship.
This court also finds it necessary that this court
Deputy officer, otherwise we'll be in trouble.
This court, while appreciating the presence of Mr. R.P. Singh, Nodal Officer, NHIDL, DCL, Executive Director, NHIDCL, Nagaland, and Mr. D.K. Singh, Authority Engineer, desires their presence as and when the matter is taken up by this court to stop if they are unable to be present for any unforeseen reason, they would be at liberty to send their representative,
Yes.
who is well conversant with the matter, to assist the court. Okay? This is the matter again after 2 weeks.
Obliged, Lordship.
For admission, item number 2.
Kalmero. I hope the learned councils will keep in mind that we have a single bench also. So,
Lordship, to make it shorter, instead of making a long submission explanation, I'll try to read the relevant paragraphs.
yes,
So that will save me the trouble of
yes,
troubling your lordship with a long submission. My
yes.
lord, I'm submitting the service rules and the judgment for notice, written reference, because all the service rule has not been annexed, or only a portion has been annexed. Lordship, the other day, my learned friend, the appellant's counsel, my lord, I'll make the as and when required, I'll make the reference. My lord, on the other day, my learned friend was making submission that his trust of argument, lordship, one submission he was making, he was that I was an ex-caterer, and only after the notification dated 18 May 2022, that is the third amendment, I was engathered and I become eligible to be considered for the post of secretary. And so, and lordship, since the interim the interim order which was issued is just after in less than 2 months, 3 months. So I don't have the requisite qualification of 2 years. That was his line of argument, lordship. So then, lordship, he was making a submission that the appellant is the senior most and the only additional secretary available who is eligible to be considered, and she's the senior most. So on the basis of seniority criteria, lordship, he had heavily relied on judgment of Jagannath Bigo, where seniority was the basis in the. So those are the areas, and he was also making a submission, my lord, that there is no suppression of material facts, and on the basis of Rule 18. My lord, Rule 18 was never challenged. So on the basis of the Rule 18, lordship, the senior most, and the only eligible person is the appellant to be considered for current judge. That was the sums in substance of my learned friend's submission the other day.
Both the parties are ladies.
Yes.
Okay.
That is how, my lord. No. Now, my lord, my life emphasis would be from the rules and the orders passed. This writ appeal has become infructuous. And in fact, the writ petition also has become infructuous. I will try to satisfy, and the issues raised by my learned friend also, I would like to, since certain issues are having raised and with regard to rules in others, I will quickly refer to the rules to recollect, to refresh your lordship's memories, and the issue as it stands today. Now, lordship, kindly appreciate this. After your lordship's direction in WBC 323 for restructuring of liberty, when liberty was given under 323 by this honorable court. Now, my lord, where your lordship passed the order in 323, lordship has pointed out the fundamental flaws in the rules. In view of your lordship judgment in 323, the First Amendment and Second Amendment of the service rule has been rendered void ab initio. Now, my lord, unlike other government service, where rules are passed, enacted under 309 of the Constitution of India, my lord, for the State Assembly, governor have the power under Article 187(3), not the speaker. My lord, the other day, my little friend was making submissions that the Learned Honorable Speaker had amended the rule after 6 days after your lordship direction, but it is not the Honorable Speaker, my lord, but the Governor under 187(3) of the Constitution. What has happened, lordship? The First Amendment and the Second Amendment and the restructuring of the Assembly on by the order dated 1/11/2021, lordship has struck down these provisions on the ground, solely on the ground that it was issued by the Honorable Speaker in exercise of his residuary power, not by the governor. And law is very clear, when any order is issued without jurisdiction or without authority, it is void of any issue. So that was a finding before by your lordship in 323. So that has bring a lot of changes in the rules, which was not pointed out the other day. Now, my lord, in 1966, a service rule was enacted for the first time. Now, when the service rule was enacted in 1966, my lord, there was no post of assistant research officer, assistant transport officer. And we were appointed in the year 1996. In that situation, through an interview, advertisement, common interview, and the only qualification was a graduate in any discipline. We appeared, petitioners, the appellant and the respondent number 1 was selected. My lord, till today, on the basis of the merit list, no seniority has been published by the department as on date. Thereafter, lordship, in the year 1999, my lord, 1966 rule was superseded, my lord, the first one, which was with effect from, my lord, 17 November 1999. Now, my lord, just quickly, lordship, may kindly go to Rule 10. I will quickly make a glance. The qualification for recruitment and promotion to any post or class of post shall be as such as specified in the 3rd schedule. Then, lordship, may kindly come, lordship, to, my lord, Rule 21, 22. May I read, my lord?
Residual power.
Yes. All matters, whether incidental or ancillary to the provisions of this or otherwise, shall be regulated in accordance with such orders as the Speaker may from time to time make. My lord, the First Amendment and Second Amendment was enacted by the Speaker in exercise of power under 21. Then in 22, my lord, subject to the provision of these rules, all questions relating to interpretation of these rules shall be referred to the Speaker, whose decision shall be final. Then, lordship, may kindly read 18. My lord, 17. Rule 17.
Yes.
All officers and staff in the Assembly Secretariat shall be subjected to the superintendence and control of the Speaker, provided the Speaker may, by general or special order, delegate to the Secretary any office power in whose regard or any of the senior-most officers in the absence of the Secretary. My lord, it is now in the subsequent amendment, it is renumbered as 18, 17 is renumbered as 18, 21 is renumbered as 22, I'll highlight. Then, lordship, may kindly come to the 2nd schedule.
Second schedule.
Yes. 2nd schedule, C, lordship has found it.
Yes.
Then, lordship, may kindly see serial number 11, assistant protocol officer, 15, assistant transport officer, 16, librarian, 17 with asterisk. Lordship has found it.
Yes.
Then, lordship, may kindly go to the next page. Serial number below stenographer, serial number 18, 11, 15, 16, and 17, the incumbents on these categories will maintain their own cadre. Lordship has found that. Now, my lord, what has happened is, Initially, in the 1966 rules, no distinction was there. We were appointed by the same advertisement, and there was no distinction made into different categories, different wings, and it was transferable from one cadre, from one wing to others. But for the first time, by the second schedule, Balot, people with 11, 15, 16, and 17 to remain in their own cadre. That's how the problem started, and that's how distinction was made. And the appellants can go up to the secretary, and I remained as assistant transport officer. There was no promotional avenues. Initially, there was no distinction made in the 1966 rule. This was the first time distinction has been made. Now, Lordship may kindly see at third schedule 1. I only read the third schedule 1.
Yes.
My Lord Secretary, Lordship is on it. The grade for which promotion to be made by a promotion from additional secretary with minimum of 2 years continuous service in the grade or as be deemed fit. That much. So, my Lord, Lordship may kindly take note of this by a promotion from additional secretary in Nagaland, minimum of 2 years grade. So this was, so only additional secretaries with 2 years of continuous service in the grade or as may be deemed fit. That was the condition. Thereafter, Lordship, so that was the position. Now, my Lord, I am coming to the next one.
Yes.
Now, my Lord, I'm coming to the next rule. The rule of 1991 was amended by the First Amendment Act in 2005. Now, Lordship may kindly see by First Amendment is on the last 2-3 pages. My Lord, notification dated 23rd February 2005.
You're referring to?
My Lord, the First Amendment 99 rules by the
First Amendment,
Yes. Lordship may kindly see the notification. 23rd February.
It's 27th.
My Lord, Lordship may see that there is a notification enclosed. Lordship may kindly see it there. The last one, yes.
Yes, 23rd February.
23rd February. In exercise of power conferred by Rule 21 of the Nagaland Legislative Secretary Assembly, the Speaker is placed to make the rules and amend. So, my Lord, this fundamental flaws was pointed out by your Lordship in 323. That Speaker does not have power under Rule 21, but it is only the Governor under 187 who can, my Lord, amend the rules. I'll come to the judgment. So, my Lord, by operation of law, since the amendment was made by the Speaker under Rule 21, Rule 21 is a residuary power, and not by the Governor under 187.3, my Lord, the first amendment made in the year 2005 has been rendered void ab initio by operation of law.
What was amended otherwise in this, by this?
My Lord, certain annexures were amended. Lordship may kindly see how the kind of what annexures has been amended. My Lord, A, B, Rule 6, Rule 14, and the first schedule was substituted.
What is the relevant one in respect of the present case?
My Lord, separate schedules have been met, but no serious distinction. Everything remains the same. The qualifications change, but schedules, my Lord, the wings has been increased from A to G. The different wings in the department into the schedule was increased from A to G. Lordship may kindly see the whole thing if Lordship desired, but not much significant change. The status remains same, but the different wings has been increased from A, B, C, D, E, F, G, up to seven different wings from A to G.
Anyway, you're saying that because of that judgment in that case?
Yes.
This has become,
Void ab initio.
okay.
Because, my Lord, it was, Lordship has, if your Lordship, I'll refer to the judgment also, Lordship.
Yes.
Then, my lord,
We'd have to read.
I'll read only the relevant
I can't
portion.
recollect.
I'll show the relevant portion. That's why, then Lordship may kindly come to the second amendment. Then, my lord, the second amendment my lord, the second amendment is 21st August 2012. Lordship is on that?
Second amendment.
Yes. Notification dated 21st August 2012. May I- Sure.
It is in this
Yes, it
compilation.
is there, it is there. I can, Lordship, I can,
Second amendment,
yes. It is there.
rules 2012,
Yes. Then Lordship, in the last, it will be in the last 2-3 pages.
last two.
Notification dated 21st August 2012.
Twenty-first August.
Yes.
All right.
Now, Lordship, may kindly see, now the rule 21, the residuary power has been renumbered as 22 here. Lordship, may kindly see in the rules also. So, my lord, the honorable speaker has amended the rules and excess of power under rule 22 of the 1999 rules. Rule 21 earlier now is renumbered as 22. Lordship, may kindly see there, rule 22 residuary powers. Now, my lord, rule 10, Lordship, may kindly see the serial number 4. Consequent upon additional rules of recruitment and condition number 10, streamline of the cadre imperatively conditionalized to appoint fresh recruitment to the lower post of the same cadre through facilitating the incumbent to the higher relevant post. P will be relevant, whereas irrespective of the relativity of posts, there shall be no intertransferability between the various schedules in the even of similar scale between the cadres. So, my lord, in the different wings still remain, and the transferability from one wing to other wing was prohibited by 10P. That's how, my lord, only the people from the general wing have had exclusive right to be promoted beyond the grade of additional secretary to secretary. That is the meaning of it. However, Lordship may kindly see, this was also without jurisdiction because this is not, amendment is not under 187(3), but under Rule 22. So, my lord, this is void ab initio, without jurisdiction. So, my lord, Lordship may kindly appreciate the fact that the first and second amendment of the rule does not have no authority in the eyes of law. It is void ab initio, since it was not. Since the amendment was not by the governor under 187(3), but by under the residuary power of the honorable speaker. Then, Lordship may kindly come to the writ appeal. My lord, page 56. My lord, yes, Lordship.
Can we just have a
Yes,
break?
yes.
And come back.
Only things, maybe it will be most of the time I'll be serving just one, na. Pass from here. Suppose table it actually, man tak kaya gitu. Man apa? So itu area apa? Pass itu. And somehow look determined.
with each employer applies.
Thereafter, Lordship, page 56. By an order dated 1/11/2021, the service was restructured. The service was structured whereby I was brought in, and which was by the speaker in exercise of order rule 1982, not by governor, and which was challenged. Then, my lord, accordingly, I was given promotion by the next page at first, page 57, and which was the subject matter of 323 at page 58. It was before Lordship. On 12/5/2022, the case was disposed of. Now, Lordship.
Your promotion was, what is this?
Page
56?
56 is the order by which the service was restructured and then whereby another I was brought into the general cabinet.
Okay.
And thereafter, page 57 is the promotion order,
To the post of,
additional secretary in the general cabinet.
from additional transport
Yes.
to additional general.
Yes, yes. But these two have been challenged in page 58 also.
The both are supposed to be at par, is it?
Yes. both are supposed to be.
But how is it promotion then?
My lord, he was in cadre. Pre-designated as additional secretary general. in the general cabinet. Not us. Then my lord at 58. This is Lordship judgment of 12/5/2022. In fact, filing of the writ petition that Adjournment was missing in disguise for all. Now Lordship kindly come to,
There were how many? 4 writ petitioners.
yes. Now Lordship kindly come to page 80. Page 29 to, my lord, I'll read 3 paragraphs. From 29, my lord, page 80, paragraph 29.
Yes.
The imperial memorandum restructuring the cadre of the operative post by the respondent military, held by the respondent military and military, same from the third shooting team to Shito Day has been done in the sense of power conferred above the rule 12 and 22 of the rules of 1999 as amended in 2012, rule provides for relaxation of rule in exceptional cases, rule 22 is a disciplinary power. The memorandum also provides that the same decision in the exercise of power conferred by the proviso to Article 157 of the Constitution of India upon the Speaker of the State Assembly. Then 13 Lordship, I believe, from the above abstract, it is said that Article 157A provides the House. Malakan, allow me to skip 130 to save time.
Yes.
31. Rules of 1999 was framed in the exercise of powers conferred under clause 3 of 187 of the Constitution of India, and it was laid before the State Assembly. As for the office memorandum in the one in the same does not indicate as to under which particular such the Speaker. Moreover, the power to elect the rules from the language of the same, it has to be exercised only in the Speaker is satisfied with the operation of any more condition of the service of an officer or staff serving the Assembly Secretary is post condition. In any particular case, cases are therefore by an order disputes with the relax the requirements of the provisions to such extent and to such conditions as to be necessary for dealing with the case is in a just and equitable manner. In a present case, the legal income is not in respect of the section of rules or condition of service of rules, but in a process of restructuring of cadre by and catering the post of particular schedule to another. Further, such exercise has to be done in a just and equitable manner, which means the empty hardship should not be caused to other employees for the relaxation of provisions of the rule. As for rule 2 of the rules of 1999 as amended as been held, then what the dispute powers of the Speaker does not include the power to amend the rules, therefore the said rule will instruct the cadre of the post under the Assembly Secretary cannot be sustained. Then Lordship will kindly allow me to read 34. Paragraph 34. In case of state of Manipur such as public sport
held that an unconstitutional law be either due to lack of legislative competence or in violation of fundamental rights or even under contrary to the Constitution of India is quite a big issue. Then number 35. Therefore, upon due consideration of the matter in its clarity and the finding arrived at the preceding paragraph, which do not say the rights of the respondent as crystallized in the order, she has acquired crystallized under use of statistical. Right? Therefore, the case of such and such are found to be not applicable to her case in more the fact and circumstances, in those also not similar in the result are found to be unsustainable and hereby quashed and set aside. However, the same shall not be barred as when of it is concerned for considering the restructuring of the various posts of the Assembly Secretary, which should otherwise need to be done in accordance with the relevant provisions of law and practicing the Constitution, the rights and interests of all stakeholders. Then, my lord, Lordship depended on to page 89. Thereafter, my lord, on 18th of May 2022, and exercise of power under Article 1, Clause 3 of the 1, Article 157 of the Constitution of India, the Governor of Nagaland, in consultation with the Speaker of Nagaland, hereby makes the following amendment rules, such and such. Then, my lord, Rule 10, it will be called the third amendment, my lord, portion you can see 4, Rule 4. In Rule 10, under the caption streamlining of existing data, the existing clause A and B are replaced by the following. A, there shall be no intertransferability between the cadre schedules up to the rank of chief secretary. B, there shall be no distinction of cadre above the level of chief secretary in the assignment of duty, distribution of work for all matters and for all service matters. So, my lord, up to the rank of joint secretary, there will be no transferability. Then, my lord, from the rank of additional secretary and more. B, there will be no distinction above the level of joint secretary in the assignment of duties, distribution of work for other service matters. So, from the additional secretary, no distinction will be made from the different streams. So, convergence in the grade of in the level of additional secretary. Separate stream will be then joint secretary, then additional secretary and more mother is purely administrative in nature, so no distinction in that convergence in the grade of additional secretary, that is the meaning. Then mother rule second 5, rule 2, under the caption appointing authority.
Mr. Takamasa, up till joint secretary, you can transfer.
No transfer.
Up till joint secretary.
Up till joint secretary. You maintain your own stream.
Up till joint secretary.
Until joint secretary.
But additional secretary, there will be no
No distinction.
distinction.
Yes.
That's
So
it, that
you
will.
can allow me to read A. There shall be no intertransferability between the cadres / details up to the rank of joint secretary.
Yes, up to the rank of joint secretary.
Initially, Lordship, initially the word cadre was used.
Hmm.
Then they have realized that this error mistakes of mother cadres / detail, because there is only one cadre, mother belong to different streams. The cadre is a cadre of Nagaland Legislative Assembly. Then B, there shall be no distinction of cadre above the level of joint secretary in the assignment of duties, distribution of work for all other service matters. So no distinction from the grade of additional secretary upward. Then number B, Rule 12 is amended. Now the secretary and additional secretary shall be appointed by the governor on the recommendation of the speaker in consultation with the chief minister. Rule 12. So, pause here for a moment. The post of secretary assembly, my lord, is similar to chief secretary. My lord, the secretary assembly is the member secretary of all the assembly, which is all the assembly committees. She participates. Secretary assembly participates in all the assembly committees as the member secretary. So, my lord, the government will definitely require a secretary who have the confidence of the government, like the chief secretary. So it is not promotion by seniority, it is purely selection post. That is how, my lord, the secretary of the additional secretary shall be appointed by the governor under the constitutional speaker in consultation with the chief secretary. So, my lord, for appointment to the post of secretary and additional secretary is under recommendation of the speaker in consultation with the chief minister. So it is by selection, not on the basis of seniority, like the chief secretary. My lord, that issue was, this was also challenged by my learned friend in the judgment, I will show. Then, lordship, we can go to page 91, B.
91,
Yes.
B.
Yes. In the third schedule,
Yes.
in the third schedule number 1007, the following shall replace the existing entry. By promotion from the grade of additional secretary or equivalent in the assembly secretary with a minimum of 2 years continuous service in the grade if deemed fit by the appointing authority. But initially the word equivalent was missing in the, was not there in the original rule of 1999, which I have referred to. Question may kindly go back to the rule of 1999 once. And
99, which amendment? First, second, or
the original 99.
original 99?
Yes. The schedule 1. One of the schedule 3. Schedule 3. I read that portion. The post of eligibility for secretary.
Third schedule.
Yes, secretary mother, Toshi Nepali, we directively by promotion from additional secretary with minimum of 2 years continuous service in the grade or as may deem fit. Now, the word equivalent is added by the amendment. Toshi Nepali, read that. Third sheet.
Yes, equivalent. Yes.
Equivalent. So by putting the word equivalent, now mother, everyone from all the additional secretaries from all the wings have to make eligible. Additional secretary or equivalent with 2 years. The word equivalent is added.
Who are the equivalents?
Another presently notion OST official on special duty alert to the honorable speaker is in the grade of additional secretary. Then the respondent number. And that
Respondent number 1 is now,
I
no, is now what?
additional secretary.
No more transport.
Not as per the rule, is additional secretary. No more transport.
No more
distinction
transport.
to make in
There'll be
terms of-
no distinction.
No distinction. So I am the additional secretary holding the charge.
So OSD, petitioner and the private respondent.
Earlier, now retired, there was an additional secretary from the library wing also.
Library.
Because there are different wings in the assembly. So we come up. No shit.
So this equivalent was inserted
Yes, right.
and this rule was challenged
Yes, in the rejected.
in the writ petition.
In
It was,
the-
it was, since the rule was challenged, it was before the division bench.
Gotcha.
Then ultimately it was dismissed.
Yes.
Okay.
Now motion is kindly appreciated.
So as on today, this rule stands.
Answer. Because the other day, my learned friend has made a submission that we did not file any appeal. So the rule, as on today, the rule stands, which has taken its finality. Now motion was the kindly appreciate the fact that rule, rule 15. In the original rule, it should be rule 17. Because that will be only confined to the rule of original because rule 7.
Control and discipline,
Control and discipline, then rule 22.
22.
Interpretation.
Hmm.
Subject to the provision of this rules, all questions relating to the interpretation of this rule shall be referred to the speaker whose decision shall be final. Then 23, removal of difficulties. If any difficulty arises in giving effect to any of the provisions, this rules the speaker may by order in written or specified as to what appears to him to be necessary for the purpose of removing the difficulty.
This remains.
Remains, then rule 17. Rule 17.
Control and discipline.
All officers and staff in the assembly secretary shall subject to the superintendence and control of this speaker, provided the speaker may by general or special order delegate to the secretary any office power in this regard or any of the senior-most officers in the absence of the secretary. Now it is 18, madam. But in the original it is 17.
Okay, now it's 18.
18. So, madam,
So your appointment is on this basis?
yes. Now, madam, rule 70, looking at the rule. And glance at the rule document clearly shows that unlike the other service rules, Honorable Speaker cannot have plenary power. Because disciplinary powers to try to interpret the rules, try to remove difficulties, and to appoint any of the senior most when the secretary is absent. Plenary power is given, discretionary power is also given to the Honorable Speaker. The reason being, Lordship, even for appointment of a person on stopgap arrangement as holding the current charge, Lordship, tomorrow the secretary will go on leave. Let us assume as when the secretary went on leave, there were occasions where the appellant was also allowed to hold charge, current charge, for the time being when the secretary was on leave. The issue is, my lord, that post being so sensitive, even for holding as a current charge, it should have the confidence of the government. That is the issue. But for chief secretary, even for all charge for chief secretary, that person should have the confidence of the government. That's how, mother, any person in the grade of principal secretary or senior secretary can be appointed. No seniority for chief secretary, because lordships are well aware. That principle is applied here. So, mother, that is the situation, and mother, besides the third amendment, the residuary powers, the plenary powers given to Honorable Speaker is not challenged by the Honorable Speaker in the before a report. So, my lord, the appellant has already subjected to the plenary power of the Honorable Speaker. That is what I'm trying to say. So, in that kind of a situation, my lord, whether discretionary power, when so much discretionary power is given to the Honorable Speaker, whether a mandamus, whether a writ will lie against the exercise of discretionary power of the Honorable Speaker. That is the issue. Because, my lord, holding a current charge is only exercise of discretionary power, and when seniority is not the basis at all. So that principle has to be applied even for current charge. In fact, even to give current charge, anybody, as a matter of principle, the consent of the approval of the governor, the chief minister is mandatory. It's a prerequisite by the speaker. Because, my lord, this honorable, whoever is in charge of the secretary will sit in the assembly, in the committee proceedings. My lord, committee proceeding is part of the decision making process. All provisions, all votes are made by in the committee. I had the opportunity being a chairman of the committee for several times. So it is the speaker, it is the secretary who sit all around, maintain all the minutes, participates in the process. That is the issue. Now, my lord, thereafter, my lord, lordship, this was challenged in 92. The third amendment was challenged. So, my lord, lordship, you can take note of the fact that first amendment and second amendment is quite a big issue. So the only rule put in the field is the original 99 rules and the third amendment. Now, my lord, the judgment is placed before Lordship may kindly refer to that. My lord, I will follow paragraph. My lord, I have submitted since it is not annexed 92, the 92 judgment, I have submitted about it.
This writ appeal is against the order passed in which writ petition?
My lord, this is IA 1160.
In arising out of WPC 144, is it?
I order dated
The writ petition is 144.
petition is 144. And my lord, the IA 116 of 2022.
116,
Yes, IA 116.
2022.
order dated 12/18/2022, by which the earlier export interim order was modified. 12/8/2022.
8/2022.
Yes.
This is the under challenge in this writ appeal. In this writ appeal.
Yes. My lord, the export interim order against me was 22/7/2022. My lord, can you allow me the submission of my learned friend C.P. Jamia? My lord, I would like to refer two paragraphs, paragraph 7 and 8. I'll not refer to my submission. I know this. With his submission.
In 92.
Yes. Paragraph 7 there.
Just a minute.
Yes. I'm reading paragraph 7 and 8, this submission of other friend. Then I'll go to some paragraphs of the unmerit.
You want to read 7 and 8?
Yes. There it is.
Yes. Yes.
The letter comes senior counsel, it also submitted amended rules of litigation as made the judgment order dated 12/5/2022 redundant and effective. He submitted an amendment of rule 10A and 10B was a repetition of the earlier office memorandum. The senior counsel submitted rule 7B of the rules of litigation in a way to suit the interest of the individual by inserting the word or equivalent as a disagree. It is submitted, there is no substantive clause in the relevant rules. Grant of additional secretary, except if the post of official and special duty to speaker in the grant of additional secretary. The post of official and special duty is to fill up only by stimulus in terms of the notification to the 16 which also declared get a seat post is only for students, parents, and duty of gatherers. This is submitted rule of this is an official responsibility to the wages for the report of the gathering committee. To arrive from finding however, the respondent proceed to amend the rules in a capacious and strict manner, person introduced to stakeholders to encourage exercise and amending the rule fully arbitrary, illegal, and discriminatory in nature, and sin was done without taking into consideration the rights and interests of stakeholders as provided, as directed by the single judge. 8. It is further submitted a rule to be not only take the respondent to be part of the general favor the window of the additional secretary. By amending the third schedule A as stated, the respondent will be eligible to be promoted to the post of secretary. By the rule of the rights of the petitioner to be considered promotion greatly affected in as much as responding to the is allowed to hold the post in a general cadre, even though the status of the service is only as cadre post instead, time taking her eligible to the post of secretary by virtue of her upgraded status as additional secretary. The motion mechanic of the paragraph 29. Decision on merit.
Yes.
There.
Yes.
The Nagaland rule of 66 was repealed by the rule of 99 as amended in 2012, which comes into force in 1799. The posts of ARO and ASC will come to mention for the first time in the rule against the third schedule. It is also said that the posts of ASC and ARO have been mentioned to given the first schedule, while the post of A2 has been placed separately. In other words, the posts of ASC and ARO has increased in the general meaning where the number within the state was to rise to the rank of secretary by promotion. So far as a assistant transport officer is concerned, there appears to be no scope of promotion beyond ADO. The rule of 1999 was amended by modification of 5 which came to force with immediate effect. Under the state amendment, the post of PTU and PTU has been placed under Schedule C Whereas the post of AC and ARO has been placed under Schedule A. Therefore, the rules of 1999 was amended by notification to the well, by the speaker in exercise of Rule 22. The same amendment came into force on 21/8/2022. Then and A and B come to be inserted. Therefore, respondent will not issue the memorandum either 1/11/2021. However, direction was issued for restructuring of the data of upgraded post. Therefore, the respondent number 3 by veteran in catering the same to the third schedule. Consequently, respondent number 2 issued a notification of 1/11/2022. Being agreed with the notifications of the employees of the as filed 1/3/23. The said petition was disposed of by a judgment order registered in such in the office memorandum or such as sustainable in law. However, liberty was granted to respondents for considering federal motion to skip that. Then, Mother, 32 is about gathering review quality. Mother, I'm reading from 33. That what we have reduced is governors in the exercise of powers conferred under 187 of the Constitution of the United States, the rules of treaty review, teacher, the very single check washing has given liberty to the official respondent to assist the considering instruction of the various posts under the Assembly Secretaries, however, should be done in accordance with the provision of law. In the instant case, what is reduced is the governor in the exercise of power conferred under 187(3) was the rule of 2022, therefore, seen varies on the submission of the Federal Council to the petitioner that the action of the respondents by enacting the rules of 2022 is in contravention in violation of the 2023. Further, we are after you that there was no necessity on the part of the respondents to wait for the report of the carrier review committee. Then motion is can be to the page 40 because this preceding paragraphs are recording relevant issues. Paragraph 40. The other grounds is with regard to challenge to amendment of rule 10 by the amended rules of 2022. What we have noticed is that by amendment of rule 10, the respondents have created a meeting point of different matters at the level of twin secretaries so that there is promotional agreements for all the wings. The rules of 1999 include certain wings for further promotion beyond a particular post. However, by the amended rules of 2022, the field has been written from the level of twin secretary by providing an opportunity to all the members of the government legislative assembly irrespective of the wings to be considered for promotion. Therefore, by providing legal playing field for all the wings, we see no reasons to interfere with the amendments of rule 3 and amended rules of 22. 41. Further, the challenge has been made to the amendments of rule 12 by the rules of 2022. For the sake of against appointing an additional secretary and secretary to government under communication of speaker in consultation with the chief minister, we see no reason as to how the fundamental and constitutional rights of the petitioners are violated by the said amendments. 43. We have considered the authorities rely upon the Federal Council petitioners over on the facts and circumstances of the present case in the end. We see that same is not applicable in the present case. In your discussion here in above, we are frustrated with the present petition, but in good by way of eligibility and on merits of the case, it will be dismissed. Fortunately, we appreciate the fact that paragraph 40, everyone has been made eligible. The rule there, the query raised by my learned friend has been answered by the division band in paragraph 40. Now, also,
This amendment was dated. Where is that? It's in the writ petition,
It's in the
in the writ appeal, sorry.
it's 89.
Okay, this is the one. This is the one by which level playing field has been.
Yes,
So that's why he says that you are just 2 months old.
that's what he was claiming. That's what he was claiming.
Yes.
It's not another we have referred earlier. Now, also, Lordship may kindly come to page 94, just, it was referred the other day, but just as quick glance. The current chart given to me. 105 copy 95.
Yes.
In accordance with the provisions of such and such, as amended, read with rule 18 and the embrace of the smooth functioning of the secretary service, very pleased to indicate such and such. The Secretary Assembly Secretary with temporary office issuing charge of the secretary to administer the functioning of the secretary with effect from 5/7/2022 afternoon and subject to the outcome of the PPC 92/2022. My lord, when the order was issued, the PPC 92 was sub judice. The order shall stand cancelled automatically on the date the appointment of a fourth registered secretary taken over the charge. The two conditions subject to the outcome of the PPC 92 and her appointment on current chart automatically ceases when the color secretary is appointed in terms of the rules. Now, my lord, that is one. Now, lordship may kindly see to 138. Page 138.
Yes.
138. Okay, order.
Mm.
Start from 1. That is the interim order, possibly 3092. Other pieces, lordship may kindly see the order. This is the order dated 26/5/2022. Very well.
Yes.
The last paragraph, the interim prayer made by the petitioner to state the notification dated 18/5/2022 shall be heard on the next available date. However, any permission or appointment made in pursuant to the legislative assembly secretary rules notified by the notification dated 18/5/2022 shall be subject to the outcome of the writ petition.
Mm.
So, my lord, already there was an interim. Then a division bench were seized of the matter. With regard to promotions, so my lord, in my respectful submission, any promotion will be using the current chart given to the respondent. She challenged the petition was challenged. Petition was filed challenging the rules. If this was the interim order passed on 26/5/2022. Thereafter, my lord, the order dated 5/7/2022. By which current chart was given to me was issued after this interim order. So that's why it was mentioned subjected to the final outcome of 92.
Yes.
So, my lord, when the division bench was seized of the matter, whether it was necessary for the appellant to file 144 challenging the current chart. Because he did not file the modification of the interim order in the before the division bench. That any promotion made in terms of the rule of 22 is subject to the final outcome of this case. That is already there. That was already there. Now, my lord, that's how, my lord, since 92 is already disposed of and writ petition is rejected, we are saying that it is now the present writ appeal as well as the PPC 144 is infructuous. Because order was subjected to the final outcome of 92. Now, lordship may kindly appreciate this. The rule, the third amendment was challenged, where my eligibility for promotion to the post of secretary was also challenged. It was rejected. Now, during the pendency and an interim order was issued, because one of the prayer was that somebody would be promoted, so no promotion and a stay. So the division bench passes an interim order that any promotion may be made subjected to the final outcome of the case to the post of secretary. That was holding the field. Now, my lord, 144 was filed thereafter. Lordship may kindly read the interim order again at 138. Page 138.
This 92 was filed,
On 26/5/2022. Motion mechanism dated 139 on the top.
no, 92 was filed for challenging the amendment, isn't it?
Yes,
Bringing everyone in the common cadre.
yes,
So court said that any promotion made will be subject to the outcome.
yes. So thereafter, my lord,
Meantime, you were promoted,
thereafter,
a charge was given,
the charge was given, my lord.
and with a rider saying that,
Page is 5/7/2022 and page 94. Current charge was given subsequent to this order. Now thereafter, my lord.
No. See, how do you say it's infructuous? That's what I'm not understanding.
Because it is infructuous in the sense structure.
Hmm.
Now, my promotion
Hmm.
to my current charge was simply subjected to the final outcome of 92. Or till a current charge, or till somebody is appointed on a
Correct.
regular basis. That was the condition. Now 92 is already disposed of.
No, it only says subject to outcome. It does not say that till the disposal of this thing, you hold the charge.
Yes, but subject to the outcome is in my favor.
Outcome is in your favor.
Yes,
So you'll continue.
I am continuing.
So where's the question of
So,
infructuous?
So that is the point. Since subject to the outcome, since it is in my favor, I am continuing. In kind of a situation, then whether challenging the negation of the interim or challenging my opposing current charge is maintainable now, in view of the rejection of his petition. That is what I'm saying. Because the amendment has been upheld. This amendment court has already upheld the amendment.
No, amendment is there, which brings everything into common cadre
Yes.
from the additional
Yes.
secretary and
And it
above.
is done on the basis of seniority.
But
It is by selection.
But your arrangement is not by way of promotion. It is only a temporary
It is
arrangement.
temporary.
Temporary
Okay,
arrangement.
I'm coming to that. Because my lord, whether the petitioner have any blockers, because whether petitioner, any of the petitioner right has been violated, that issue I'm raising after I complete this submission. Either by giving me current charge, where it does not give me any higher position, it does not give me any additional increment or salary, nothing, and holding current charge as a stopgate arrangement. The Honorable Supreme Court says seniority cannot be basis and only a current charge, nobody's right is violated. No right will be violated. Because it is only a current charge, it does not give right to anybody. I'm coming to the judgment.
But is it in connection with rule 17 or 18?
Only the principle of current charge. And submit a judgment, Honorable Supreme Court judgment.
No, normally, ordinarily, any charge, what you say may apply.
My Leonard friend's home condition is that she is the severe most. And in petition 144 was filed only on the basis of seniority, not on the question of, not on the issue of eligibility. I'll show the pleadings. And when seniority is not an issue. When seniority is an issue, it is only when it is a selection post, whether for holding current charge, seniority can be the basis. And for that matter, my lord, seniority is just with determined between the parties.
Yeah, yes, that you have said. But what I was saying is that this rule 17, which has become rule 18 now.
Any of the senior most.
It says. So that's why that interpretation was there.
If the word senior most, if the word any is there, not absent, then the petition will, then the judgment will apply. It's a single judgment, high court judgment will apply. But here, it is not on the basis of any of the senior most.
It does not say senior most.
Yes, any.
It says any.
Yes. So, my lord, that is single judge made a distinction between by interpreting the word any.
Okay.
In the light of the fact that the promotion of the post of secretary is by selection.
By selection.
Senior most is not the criteria for promotion to the secretary.
Okay. Yes, please continue.
Now, my lord. So that is, that option we currently see Thereafter, my learned friends had filed the PPC 144.
Challenging your order dated
Yes,
5th July.
5th July. Now, my lord, also you can see the page 1. 122. 122 is the order. The first order ex parte against me.
That writ petition is not there, is it?
It is there. I'll come to that. I'll show some pleadings thereafter. Writ petition is over next. But first, only allow me to show the order, then I'll show you the pleadings.
122.
Yes, 122 is first, another is an ex parte against the private respondent. 22/7/2022. Mother, I'll read 126. Paragraph 7 is my submission of my learned friend.
One 126.
Yes, paragraph 4. Here in my.
Yes.
Mr. Jamir, counsel for the petitioner has submitted the petitioner is personally serving as the petitioner secretary to the board of directors after being promoted post by normal shepherd of communication of the has amended since 2/12/1999. 2011, the petitioner has gained experience of more than 2 years, 6 months in the post. The petitioner was already given the petition charge such and such. By all means, the petitioner is known as the petitioner secretary to the assembly. Notwithstanding the amendment code in 1999, the third amendment was as such, the power conferred by the proviso to Rule 15 after Rule 1999 rules cannot be exercised to keep the power to hold the current charge of secretary in power to never respondent number 2, who is not the senior most additional secretary by passing the letter to the petitioner. This is important, mother. The learned senior counsel for the petitioner also submitted that the writ petition number 92/2022 was ordered to be listed on 27/2022 for in bench for hearing in the corollary to also recite the letter relating to the opening of current charge of the post of secretary. The petitioner has refrain from mounting a challenge to the new officer in charge of which transpires and consideration the said petition to be delayed to the non-availability of the bench. The petitioner has no option but to dispute the writ petition and select the new offer as the same is to convince the petitioner and petition by referring to the unamended provisions in Rule 99 and also the amended provisions contained in the third amended rules where it comes to the petitioner has submitted that the post of additional secretary in the or the post equivalent that is the great post for the post of secretary and a minimum of 2 years of continuous service to the field post is a special for the promotion. It is sufficient that
You read complete reading.
This submission that even in order to hold current charge or temporary charge or in charge of the post, one has to have the minimum experience of 2 years of continuous service, and for such submission, he has relied upon the decision of Jagana Putosi and others reported as such and such. When the respondent and producer does not have an essential experience, not seniority experience, to be promoted to the post of secretary, and the petitioner has a requisite minimum experience, the environment order is arbitrary and unsustainable. Now, Lordship, I am reading again. The learned senior counsel for the petitioner has submitted asked the writ petition 92/22 was ordered to be listed on 27/2022 for hearing, which in the corollary would have also decided the matter relating to holding of current charge of the post of secretary. This is insufficient.
92 was the challenge of the amendment.
Yes, this is his own. This is a submission of the learned counsel that current charge also would be taken care by the PPC 92. That is insufficient.
So anyway, in other words, what you want to say is that your holding charge of the secretary has been fortified by the fact that WPC 92 has been dismissed,
Yes,
upholding the amendment rules,
yes,
which gives you a right to be in a general cadre.
yes,
And in absence of drawing of any seniority,
yes,
there cannot be any grievance against you holding the charge.
And which immunity is a criteria for motion.
So in a way, it's infructuous. That's what he
Yes,
said.
yes. And motion that take note of the submission of another friend, paragraph 4. If we are submitting the corollary issues of another judge, will also be taken care by 92. But the letter was not listed in time, so I'm filing this report. I'm only submitting his submission. I'm not, because I'm not, and he's praying to restore this order. Because the moment writ appeal is allowed and the litigation order is, if it is set aside, then this order will be restored. So that aspect has to be considered.
If writ petition is allowed, everything will go, amendment, everything will go, so there will be nothing left to be considered. But if it is dismissed, then the issue of this will come. Simple, very simple point, because the judgment, the judgment in the WPC 92, there are 35 paragraphs in 32 pages. The judgment is written. There is not even a single word mentioning about Rule 18, where the impugn order which I have challenged in the writ petition granting current charge is basing on Rule 18. So from day one, I was making a submission that no, this is different. They said no, it is command, so it should be clubbed together. So Honorable Court took it, correct? So it was clubbed together. But I said no, it is different. Issue is different. This is only pertaining to current charge, where the Speaker has issued the order under Rule 18. Therefore, the issue to be decided in this particular writ petition is pertaining to interpretation of Rule 18. Whether Speaker has the power to do this or not. That is the only issue. And in the judgment which has been dismissed, my learned friend is so proud of dismissing my case. Yes, I admit that and we have that challenge. But is there anything mentioned in these 35 paragraphs in 32 pages?
Regarding Rule
Is
18.
there anything mentioned about Rule 18? Why? It is not relevant. That is why it is not that.
All
It
right.
is not decided. That was the case
All right.
from the D1. However, the order we have to respect. So Honorable Court has passed the order. I have to confine to that.
I'm only showing his submission.
Yes, my submission is to that effect. Once it is allowed, everything will go, including the amendment. Therefore, the question of considering for current charge will not arise.
I understand.
But if it is dismissed as it is done now, then the relevant point to decide this case comes.
And also budget.
Therefore, my learned friend's submission in his introduction that writ appeal has become virtuous is baseless.
Even for me,
Without any
submission, clarification, he was
Nothing
obtaining
clarified.
I will verify that point. The only issue is, when the better two, the rate of bill, the rate issue were blocked by the letter in 1992. He must be had protested, but that order was not challenged by him. Copying the order, the two order, two petition was not challenged.
Okay. Anyway, we'll come back.
I'm not,
to,
thereafter, Mother, I've shown little bit about.
I think
violation of-
more or less the picture is clear.
Only I'll show my appointment orders. Then few paragraphs from the judgment, then I'm going.
Just sum up your submissions
Yes.
both sides,
Yes, sir.
because I
Because,
think
Mother, the idea is, I think, I am so that India for less of.
Mr.
That is our understanding.
TB Jamil is also there.
You take less time, that is understanding, because there are as much so that you can, to save time. is enough.
See, like we said at the outset, since we have something else on board, single benches.
Yes.
So that's why if you can wind up,
Actually,
Hmm.
this is the reason why I was mentioning that you take little time, that is why.
As far as
Anyway,
possible,
we will try to finish.
it is better to be in brief, Your Lordship.
the subject matter comes, is in a
Narrow
short,
area.
it's a narrow compass, I think.
You see the Lord, friend is, whether he is applying heat in run tactic here. But I'm working on the main road, so I have to explain everything.
My little friend is taking a long journey, which is not required to do. Anyway,
Okay, have a cup of tea and come back.
I have taken 1 hour, 15 minutes to complete my case. And the entire first half and second half group together, 1 hour, 15 minutes. I have completed.
All right.
अच्छा अच्छा बस आइए anything that's oh này nó dừng xe vào tôi cứ đi xe vào thằng cái gì rồi tại ni xe lệ đã cái xe máy xe vào tôi off
Mixed.
Oh.
Yeah. Minus 2, 3 there, yes, that 123. 126. Correct.
Dahil sa aswang, yes, sure.
Yes.
Can you allow me to show the initial appointments and the promotions of the parties? I wanted to show two orders.
Hmm.
Motion the management of page 47.
Yes.
This is an order dated 30th September 1986. The applicant was allowed to join with effect from 2nd September 1996, the last time. After he appeared against the same review and you were both successful. And with effect from 2nd September 1996. Now, Lordship,
Hmm.
I'm submitting, this is an extra week in my affidavit in opposition in response in WPC 144.
Hmm.
What has happened is, okay, the applicant on 3rd of September 1996, he submitted an application that she should be allowed to join with effect from, with retrospective effect from 2nd September 1996. Next year, being affidavit in opposition of so, my lord, and I was allowed.
This is the appellant.
Yes. This is her application. That's how the order was issued that she was allowed to join. With effect from. With retrospective effect from. In fact, she's joined on her. We joined together. Once she submitted this application, and this was entertained. That's how she's claiming security. Actually, interestingly, her eldest brother was under this secret. Then object, page 48. She was promoted to additional secretary with effect from 2nd September 2019 by order dated 3rd November 2019.
Yes.
Then with regard to the respondent number 1, about page 50, 49 is the order type is 50. Followed by the same, by order dated 1st October 1996, I was allowed to join with effect from 3rd September 1996. After you were qualified, page 50, the respondent number 1. You faced the same interview and on the same grade, you were declared successful by the one exam. But, I was allowed to join with effect from 3rd September 96. That's how the respondent, the applicant attorneys will be. Then, page 51, type copy 52. Please find promotion to the upgraded post of additional secretary transport. On the same date, 30th November 1998, 2019, with effect from 2nd December 2019. So, from grade of joint secretary to additional secretary grade, same date, same time. Then, Lordship Italy, turn to page 143. Page 143, mother type copy 144. This is a representation dated 31/5/2022. I pray that I submitted a representation of similarity that we provide between the parties and as per information I am very curious in terms of the result. So similarity should be determined on the basis of the merit test, not the date of training. So similarities have been determined. I will satisfy your worship with the judgment of the Honorable Supreme Court on that similarity should be on the basis of the merit list, not on the basis of the date of training. Now, my lord, 141, page 141. I had a categorical statement in my I'm showing the background. My lord, by order dated 30/11/2017 in serial number 1. One Sanjay Bala, officer OST, to the honorable speaker. She was promoted to the post of OST to the honorable speaker with effect from 4/12/2017. This is not disputed within the parties. One Sanjay Bala, OST to the OST Bala with effect from 4/12/2017 by notification 30/11/2017.
How is it relevant to your case?
Other friend is making a suggestion that she is the senior most in the grade of
Additional secretary, okay.
additional secretary. But the fact is that there is somebody as early as 2017, and this type was suppressed. So even going by her contention that on the show seniority, she's not the senior most in the grade of additional secretary. No, not true. Coming to the writ petition filed with the writ petitioner, the WBC 144 and page 24 is the writ WBC 144. Now, most of the appreciate this fact that when the writ petition was filed, the interim order dated 26/5/2022 passed in the WBC 92 was only reviewed, subject to the final outcome of the case. Now, my lord, I wish I have the time to show to read the relevant paragraphs. I have gone through this paragraph with my learned friend show. The fact that a seniority that the interim order was passed in 92 was totally suppressed. Nowhere in the writ petition section, nowhere in the submission. Number one. Number two, the fact that Sanjay Kala OST is senior most in the grade, that also was suppressed. Thirdly, Lordship, I've gone to the writ petition letter, my letter friend show. In his pleadings, it is only the only issue raised was seniority, that she is a senior most and she has got more experience. The eligibility criteria that I have served only 2.5 years, 2.5 months, and I am not qualified is totally, there's not a whisper about that in the writ petition in the pleadings. Other paragraph, 25 paragraphs are there. I have marked it, but to save time, I'm not reading it. But let my little friend show from the pleadings that on the eligibility criteria, that statement in his petition that I have served only 2.5 months, so I don't have the requisite 2 years in terms of after the third amendment. That is totally silent. This issue was, he raised this issue of eligibility for the first time when I filed my IA and before the judge, he made the oral submission on this and he put it as a ground in the writ appeal before the Honorable Court. But in 144, this is a subject matter. So when in the model petition, this issue is not raised, whether the petitioner is entitled to raise this issue at this stage. Nowhere. Then Lordship, in page 42, I only read one paragraph, paragraph 22, page 42.
Yes.
That the petitioner takes to state the cause of action to file a preliminary petition arose to the company of the Bureau of Fishing and charge of secretary to respond on the part of execution by the supporting the post of secretary and the giving of authority to set post as prescribed in the rule itself is because of the order and rule the non-given date of the post of secretary is on the file dispute. This present petition owing to the uncertainty of the disposal of the officer petition in this pertinent issue, and it is a pertinent issue to be decided that this Honorable Court as to push on the eligibility of the post of chief in charge of secretary during the pendency of this the issue raised in this the interim order was 26/5/2022 was a rate appeal, then interpretation 92 was not brought to the notice of the legislative judge. When the interim ex parte interim order was issued. That's how, my lord, I'm alleging that there is serious suppression of material facts. Had the legislative judge would let know that there is an interim order passed by the division bench in 92 and the matter is not released, you would have intervened and passed the interim order. That is what I am trying to highlight to your lordship. Now, my lord, in IA, then I filed IA 116/2022. My lord, the pleading is annexed at page 100. My lord, Lordship, if I take note of my submission in paragraph 8, and to save time, I'm not reading my lord, paragraph 8, 11 to 14. All the issues I have raised, but to save time, my lord, since we are constrained with time, I'm not reading. Then, my lord, at 145. 145 is the order passed in IA. Lordship, we kindly at 150, my lord, I to save time, I'm not reading. Lordship, we kindly take note of at 150 Roman 3 and Roman 4 at 151. Then, Lordship, I'm not reading the paragraphs. Then the operative portion, of course, is paragraph 6, 7, and 8. Now, my lord, heavy reliance was given by my learned friend, and which was accepted, my lord, by the learned single judge decision 2007 3 GLB 389 Jagannath Bigo. My lord, can you allow me to refer a paragraph there? 2007 3 GLB 389, which was the basis on which the then the single judge that passed the judgment. And my lord, I will only read one paragraph.
Yes.
Paragraph 4 and 10, are relevant portion. Only I read the paragraph 4 at page, my lord, this is a single bench judgment. It did not be counting on the logic since this was relied upon. I like to read paragraph 4. I'll read only one paragraph, only this much. There, paragraph 4, page 390.
Yes.
At or above the sum and notification dated 1/7/2020 by the government of Assam, it was provided that the Community of Assam Assistant Church with graduate skill of grade in the provincialized high school, higher secondary school would be counted for the date of joining us as assistant teachers. Subsequent thereto in exercise of power and duty of the Constitution of India, the Assam Secondary Education Law 2003 thereafter as used for referring for including the recruitment and condition of service of person appointed Assam Secondary Education Provincialized Service. In terms of Law 14(2), the seniority of teachers will be considered for promotion to the post of headmaster, head district superintendent, higher secondary school was to be determined from the date of receipt of graduate skill as contemplated in Rule 24(2). In this case, Lordship, promotion was strictly on the basis of seniority in terms of the rules. So the learned single judge held that even current judge should be on the basis of seniority. Then Lordship, the analysis paragraph 10 is the where is it the seniority should be the criteria. Whereas Lordship, so my lord, for the learned single judge, so then before the learned single judge, to apply the principle of ratio, I was making a distinction that here it is a purely selection post. Seniority is not an issue for promotion to secretary, and discretionary power is there. So this judgment has no relation because seniority cannot be a criteria for current judge here. That is what I try to distinguish. One. Now, Lordship, I am submitting a judgment 2007-10 SCC 402. No one has the right to ask for or stick to current charge duty and seniority is not a consideration. Under 2007-10 SCC 402, paragraph 5, 13, 14, and 15. In fact, this is I don't know what HPC master. Under to save time, I am reading 13, 14, and 15. Paragraph 5 is the fact of the case. Facts. Here in paragraph 30, page
Yes.
406. The arrangement contemplated in this order plainly do not amount to a promotion of government to the post of treasurer. The distinction between a situation where a government servant is promoted to a higher post or one where he is rarely asked to discharge his duties at the higher post is too clear to require any regulation. Asking an officer to substantially post and lower post merely to discharge his duties at a higher post will not be treated as a promotion. In such a case, he does not get the salary of the higher post, but in case only one his service parlance is told a charge allowance. Such situations are contemplated where exigencies of public service necessitates such arrangements or limit the situation of seniority do not enter into it. Where a person continues to hold a substantive lower post can only discharge the duties of the higher post essentially as a stop gate arrangement. Instead of such as such, Mr. Sharma was given his current duty charge of the post of executive engineer, the order of the chief administrator, and the same charge was also revoked. The same activity were covered to use no such and such, whereafter the chief administrator in the fact was within his powers to issue the two orders. We are constrained to say that the High Court extended its extraordinary jurisdiction under Article 26 of the Constitution of India to the knowledge. No one has a right to ask for or stick to a current charge. The Indian order did not cause any financial loss or of any kind to Sharma, and there is no cause of action whatsoever to revoke this court. It was a dead-end misuse of the process of the court. In the present case, Lordship, I am not given any charge allowance also. That is one. Then mother on locus, 2013 for SCC, 2013 for SCC, 465, paragraph 9 and 10.
This is regarding,
Mother, the person agrees with it, with person agrees. Mother, I'll read two paragraphs, paragraph 9 and 10, 475, what is following?
yes.
Person agrees, it is in the position that a stranger will not be permitted to enter the legal proceedings unless he satisfies the authority or falls within the category of the agreed person. Only a person who has suffered or suffers from a legal injury can challenge the action in a court of law. Every petition under 226 of the Constitution is available period for the purpose of enforcing a statutory or legal right of when there's a complaint that there has been breach of duty and part of the authorities. Then to save time, I allow me to read paragraph 10. A legal right means an entitlement arising out of legal rules, thus it will be defined as an advantage or benefit or comfort upon a person by the rule of law. The person, the expression person agreed does not include the person who suffers from psychological or an imaginary injury. The person agreed must therefore necessarily be one whose right of increase has been adversely affected or jeopardized. So, my lord, whether the petitioner in the first place, the appellant had the locus standing to file the writ petition challenging for holding of a current charge. When no current charge allowance is given to me, no scale, no privileges, I am holding my substantive post or additional secretary as a stronger management. I hold the holding. So, my lord, these two judgments that I bring to this submitting for worship was squarely over the present case. Because first, the petitioner appellant has to prove that his right has been violated. Now, by holding giving current charge without any charge announced to me as a smoke cage, what right has been violated? Now, my lord, on suppression of material facts, my lord, same time I'm not reading 2008 12 SEC 481, paragraph 34 and 38. Just the same time, my lord, I'm not reading it. Then, my lord, next sentence.
Paragraph 34.
38. Then, one of the next statement. No mandamus rely on discretionary power. 1984, 3 SCC 3258, paragraph 13.
3258.
1984, 3 SCC 258.
258.
Paragraph 13. I will read. Now, Mother, 266, page 266, paragraph 13. I'll read only that. Here,
Yes.
in order the writ of mandamus be issued to compel the commissioner to find the license, it must be shown that under the act, a rules there was a legal duty imposed upon the commissioner to issue the license under rule 7 of the rules without the prior approval of the state government, and that such and such that the corresponding legal right for its enforcement. No mandamus will lie where the duty so enforced is of discretionary nature. Nor will a mandamus issue to compel the performance of such the public authority or authority of an act contrary to law. And just to save time. So, my lord, the discretionary power given, Dr. Dekani, subject to repetition, Dr. Dekani appreciate the fact that honorable speaker under the rules enacted under 157(3) of the Constitution have plenary power. And what discretionary power is given to the Honorable Speaker under the rules, and whose provisions, special rule from rule 15, 22, 23, 21, 22, 23, Lordship, has not been challenged. That so that and that's context, I am submitting. Then Lordship, I am submitting another judgment. Other parties are bound by proceedings. I'll only take the citation to say that other parties are bound by proceedings. Other 2011, 15 SEC 453, paragraph 6 and 7. By respectful submission, my lord, the appellants are bound by proceedings in WPC 144. He cannot enlarge the scope beyond what he has stated in 144. Because, my lord, IA is only an offshore with regard to interim order. And when he's making a submission that my lord security, and when he's making a submission that I have to do half-year service, when it is not needed. Finally, my lord, seniority as per meritless and not date of joining. Other 2004, 2 SCC 459, paragraph 11 and 12. Let me read the paragraph here. Page 462, Roger.
Paragraph 11.
Yes, I'm reading another page 4, paragraph 11, here.
Yes.
It is also looked at from another, it can be looked from another angle. The applicant was under extension of 31, 1987 with joint. It was open to the Service Commission or the government at that stage to direct removal of his name from the list of selected candidates. Whether the commission or the government thought it was great to do so. On the other hand, the government extended the training period with the applicant joined the post in several political seniority lists after applicant name was placed higher. For more than a decade, respondent did not question the position. After a very long period, it was not open to respondent one to keep the turnaround and see that the extension not back to applicant was not in accordance with the that put the applicant and respondent were selected in the same selection, and the applicant was more meritorious in terms of marks secured by him in the selection process and ranked above the respondent number 1. And inclusive ranking and considering industry security cannot be disturbed, and rise flowing from such ranking cannot be denied merely because there was some delay in trading. Although more so when such delay was only of 8 days, and also an amount of getting released from government for reasons beyond his control, which only seemed to have weight with the state government in accordance into a court extension of the High Court seems to have lost sight of the fact that it was not a case of where reasons were absent in the order of the government to exclude the journey. On the contrary, the order indicates the reason why the appellant has sought for extension in government, taking note of the appellant's active position has granted extension. High Court had previously held that two reasons were indicated. In the above paper of the analytical conclusion is that appellant was to be placed higher in the seniority list. In the seniority list, and respondent number 1 in terms of the industry merit ranking assigned by the Service Commission. So, my lord, and especially when the British parties, the appellant and the respondents were on different wings, and deal with those related tests whatsoever has been published.
See, this is under the Andhra Pradesh State and Subordinate Service Rules.
Yes.
What would be the post? Section assistant, section officer.
So, my lord, summing up, Summing up. Okay. In a given situation. Subject to the petition, 144 will decide the merit of the case. So, my lord, and lordship, the value of lordship is that when they go for the interim order, he move on the ground that he is the senior most, she is the senior most, and on the basis of the senior most, by suppressing letter of fact, exporting interim order. Accordingly, lordship, I have to file an IA 116 and satisfy the court that in terms of the rule, it's not seniority but merit. It's a selection post. So to hold that merit, the seniority is a sole criteria to be considered, and also to ensure that I am eligible. But only to that extent I have to make a submission to satisfy the court. Accordingly, the learned single judge had to make a verification, and it was applicable. We clearly have the learned single judge that in view of the improper protection of the law and facts in law, the earlier order was passed. So that to that extent, the learned single judge has to go into the rules. It is not the case that the merit has to be decided. But in that particular fact, this was done in that way. That is one. Secondly, lordship. Now, what is the issue? I was given in charge. The assembly secretary cannot function without the secretary in charge because of which is more responsibility and executive responsibility as well as legislative duties. Accordingly, the exercise of the discretionary power and in terms of the rules as of 1999 as amended by the third amendment, honorable speaker who have the plenary power in exercise of his discretionary power has given the current judge. Any other senior most. Now, if now I'm there since May, since for the last more than 2 years I functioned in that position. Now, my lord, either if you look from either side of the coin, either if I'm my experience will be counted from the date of petitioner secretary since 2019 as petitioner secretary transport, or from the date of the enactment of the rule. Fifth, I have more than 2 years of service, whichever way. Whichever way, now I'm eligible. That aspect belongs to the section. One. So now, not promoting someone or delaying the delivery of the document which grievances my other friend was raising directly have got nothing to do with me. Now, my lord, in that situation, if the modification of the interim order, after I continue for more than 2 years, interfered in this stage, what happens? It will be a situation where the export interim order will be right, and there will be no secretary. One and the other side of the organ of the three organs, there will be great as unlawful situation whereby the legislative function will be totally stopped because no assembly committee can function without a designated secretary. So that aspect has to also look into the matter. So in that way of the matter, in all fairness, this is a situation. That is how I am saying infractions. And in that, from that point of view, actually it is a case where the case of the writ appeal as well as the writ petition should close with an observation or a direction to the competent authority to go for regular appointment to the post of secretary. If there is, tell search as if I am she is eligible or if I am eligible in terms of the rule. We were selected. It will be fair to everyone. So that aspect also may be taken into consideration. Much of that.
Finally, Your Lordship, I got my turn. I will try to conclude with it.
Okay.
My first submission, Your Worship, will be on Rule 18 and its implementation. And my second submission will be on the extent of interference by appellate court in written. Two submission, 10 minutes, 10 minutes. Coming to my first submission. May I take Your Worship to Rule 18, which is at page 97. Nine, sir.
Yes,
Great. May I read now?
yes.
All officers and staff in the assembly secretary shall be subject to the superintendent's supervision, provided the speaker may, by general or special, delegate to the secretary, office or in this regard, or any of the senior officers in absence of. I respectful submission to worship. The issue before the worship is interpretation of Rule 18, and in particular, how the phrase any of the senior most officer is really interpreted. Now, therefore, Your Worship, at the outset, just the reverse now, I may be allowed to refer to one or two, where the constitutional bench has left on the principle for the interpretation of statutory provision. That is 2014, volume 3, SCC 92. But in the backdrop of this, Rule 18 has to be.
What are the relevant paragraphs?
Paragraph, I will just paragraph 43, 44, 45, but I will read out only paragraph 44, first two line and paragraph 4. Paragraph 44, Roshi has got it.
Yes.
Just read out the first two line. No word in a statement has to be construed as surpluses. No word can be rendered ineffective or purposeless. Paragraph 45. You say that. Paragraph 45. The subparagraph 27.
Yes.
The court has to keep in mind the fact that while interpreting the provision of a statute, it can neither add nor subtract even a single word. That is. Now, the rule is as that of a constitutional bench. Nothing can be deleted or added.
Yes.
The submission of the Remedial Council for the appellant is twofold. Firstly, according to him, any of the senior most officer must be the senior most officer. That is the submission, the senior most officer. Now, if that interpretation accepted, Your Worship, it will make the word any appearing before the word senior most in Rule 18 redundant. The purpose is, Your Worship, and which is not permissible as per the principle of all laid down by the constitutional bench. Now, second submission advanced by the appellant is that the senior most officer must be one who is eligible to be promoted to the post of secretary. But Rule 18 only says any of the senior most officer, whether 1 month old, 2 month old, 1 year old, that is not the thing. Any of the senior officer. It does not say that any of the senior most officer who is eligible to be promoted.
So if the interpretation of the appellant is accepted, it will amount to adding something to Rule 18, which is not permissible as per the law laid on by the Constitution Bench. Now, how the learned single judge interpreted Rule 18? May I take your worship to page 158? The order we is under the 158 is a relevant paragraph 6. Also, that's what it.
Yes.
Now, I'll come down to the directive, the second paragraph, 18, control and discipline, which I read out. Now, the last paragraph. As can be seen, the word any appearing in second paragraph of the rule precedes the words in the most. Therefore, reading of the whole rule will mean that the notice speaker can delegate charge of any of the office to any of the senior most officer in the signatory proportion. In my respectful submission. So, this is in consonance with Rule 18 and in consonance with the principle of law laid down by the Constitutional Bench as to how this adjournment provision is to be interpreted. Now, your worship. So there's no influence in the order of the single judge. Now, coming to the second round, your worship. On the extent of interference by appellate court, irrevocable, to what extent? An appellate court can interfere. Now, in intra-court appeal, your worship, it has been held by this only that a judgment on order passed by learned single judge can be set aside only when there is patent error on the face of the report, or the judgment is against the established principle of law. In support, I am relying on 2004, volume 1, GLT 117. Para 26 years. Para 26.
Yes.
While dealing with the present appeal, one has to bear in mind that a writ appeal is really not a stated appeal deferred against the judgment and order of an inferior or superior. The appeal interested in a high court from one court to another is really an appeal from one coordinate bench to another coordinate bench, and it is for this reason that the writ court cannot be issued by one bench of the high court. Of the High Court to another bench of the High Court, nor can even the Supreme Court issue it to a High Court. Thus, unlike an appeal, in general, a writ appeal is an appeal on principle, and that is why, unlike an appeal in an ordinary sense, such as a criminal appeal, where the whole evidence on record is examined anew by the appellate court, what is really examined in writ appeal is the legality and validity of the judgment and or order of the single judge. And it can be set aside or should be set aside only when there is patent error on the face of the report or the judgment is against the established or settled principle. As submitted, the learned single judge has interpreted it as per the law established. Of principle of law, let on the court. So the judgment is as per the settled principle of law, and therefore, no interference is called for. But the learned single judge has interfered in conformity
with the principle of law laid down by that. It cannot be said that the interim order was against the established principle. Now, your lordships. Also considering the scope of intercourt appeal, the address court has also held that unless the finding of the various single process reverse, no interference is called for, and it is reported by your lordship in 2020 volume 16 SEC 4. Paragraph 36 to 39 and 44, lordship, I read out only paragraph 34. There's 3 lines. Paragraph 36 to 39 and 44, but I will be reading out only. Lordship, that's got it.
There is no para 44.
Your lordship, maybe, yes, in SEC, your lordship can. So your lordship, my apology, I have from the website. It starts from further in Narendra and Company Private Limited. Paragraph 42.
How does it start?
Further in Narendra and Company Private Limited versus movement. volume 16, SEC 478. Ramachandra Reddy versus State of Telangana and others.
What do you mean? Yes, it's here. I got it.
Further, in Narendra and Company, while considering the scope of the intercourt activities, court has held that unless the appellate bench concludes that a finding of the earlier single pledge are reversed, it shall not disturb the same pledge unless it is reversed. And what is reverse, Your Worship? The Supreme Court has defined, discussed it in 1999, volume 2, SEC 10. What is reverse?
Please repeat again.
And what is reverse? Your Worship?
No, the citation.
Citation 1999, volume 2, SEC, page 10. Para 10.
Yes, yes, yes.
Yes. A broad distinction has therefore to be maintained the decisions which are reversed and those which are not. If a decision is arrived at on no evidence or evidence which is thoroughly unreliable and no reasonable person would have act upon it, the order will be reversed. But if there is some evidence on record which is acceptable and which we rely upon, however complex it may be, the conclusion would not be treated as reversed and the findings would not be interpreted. In my respectful submission, the order is under challenge passed by the elders and the judge is in conformity with the king and which has been interpreted as per the principle of law laid down by the constitutional bench. Therefore, it cannot be said to be so unreasonable so as to come within the ambit of the reverse. And therefore, Your Worship, in my respectful submission, no interference is called. And my second thing, Your Worship, submission. Another aspect of the matter which portion was taken. The submission advanced by the appellant is that there are two conflicting orders, and therefore the same need to be decided by this court. As submitted, the issue to be decided is interpretation of Rule 18. And the one and only issue in writ petition 144 of 2022 is interpretation of Rule 18. Therefore, Your Lordship, in my respectful submission, if Your Lordship interprets Rule 18, in this proceeding, Your Lordship, nothing will remain to be decided in writ petition 144 of 2022. And the interim order being in the nature of interim, Your Lordship, therefore, without interfering with the same, the active, my respectful submission, various active to be discussed with the observation for disposal of writ petition 144 of 2022 as expeditiously as possible, Your Lordship. Thank you. Much obliged.
How long will you take, Mr. Javid?
For me, he said 5 minutes. Yes. 5 minutes for me, 5 minutes to his reply, and 5 minutes to my learned friend's submissions.
Okay.
But at the outset, Lordship, first, let me respond to my learned friend, Mr. Takamasa, presenting the response number 1. At the outset, before I make reply, my learned friend has entered into the merits of the case, which I feel that it is irrelevant to enter into the merits of the case. The writ appeal itself is against the vacation of an interim order, and the interim order was passed by this honorable court on the ground of establishment of a prima facie case. The word prima facie case is mentioned in the order itself. The single judge, while passing the interim order, has not passed on the basis of the merit, but on hearing the submissions. That day the speaker was also heard, and then conclusion was arrived on the ground of establishment of a prima facie case, and the interim order was passed. That came to be challenged by the present private respondent on the ground that there is suppression of material facts. Therefore, it should be vacated. So what and the more main trust, I will come to the later stage, but let me go one by one. I'll go a little faster since time is running out. First submission was on the engagement. On my submission, that my learned friend has made a reference to my submission that on 18/5/2022 only, on that day, the appellant, the respondent number 1 has been brought to the gate. That is my submission. That is what my learned friend has referred to. But my submission is meant to be brought to the gate by the new amendment on 18/5/2022. Although it is not engagement, but meant to be engaged. That was my submission. Whereas, kindly come to page 152, or I can just read out to save time. 152. On the contrary, it is the submission of my learned friend, paragraph 3, the bottom page 152.
Yes.
Mr. Daga Masala, General Counsel, the parent for applicant submitted that the rules of 1999 up to the third amendment and as it stands today, that is 18/5/2022, has made the applicant also eligible for promotion to the post of Secretary of the Nagaland Legislative Assembly Secretary. So this is not my submission, but it is his submission. That the respondent number 1 was brought to the gather on 18/5/2022. Second, that is my reply. It is not my submission. my submission was meant to be brought to the caterer by the new amendment, whereas that issue will come later on, whether she was brought to the caterer or not. So counting from that day, I can see that it's time, period. Now, second submission was the writ appeal is infructuous. That was the submission. My Lord Silo has also put a question, in what manner it has become infructuous. Infructuous may be relevant in the sense only when the writ petition is allowed. Once allowed, the tree will be cut from the steep bottom, and entire tree will be fallen. And there will be nothing left to discuss about bringing to the caterer or not bringing to the caterer, equivalence or not equivalence. Once the amendment is quashed, then the question of issue of equivalence will not come. When that issue doesn't come, there is no question of private respondent coming to the caterer. Therefore, to that extent, once it is allowed, there will be nothing left to be considered in this writ petition. But since the writ petition is dismissed, now the issue who should hold the current charge has become relevant. Now, the third point which my learned friend has referred to is page 95. That is Tribunal Order 57/2022.
Yes.
By editing this order, Lordship will find. By invoking Rule 18, the Union order has been passed. Therefore, the relevant issue in the present case is with regard to the interpretation of Rule 18, which talks about the temporary current charge. Now, temporary officiating charge of the secretary. This is very important also. Why it is important, Lordships? Because the submission of my learned friend was that the interim order has been obtained by separation of material facts, and that material fact is about the interim order which was passed in the writ petition 92 of 2022, which was passed on 26th of May 2022. And the present writ petition has been filed thereafter, and this fact was not brought to the notice of the court while obtaining the interim order. That was the submission made by my learned friend. That is very, very relevant and very important. Taking into consideration of the order, the interim order passed on 26/5/2022 is any appointment or promotion shall be subject to the final outcome of the case. That was the interim order. And that fact was not brought to the notice of the noble court, and we have obtained the interim order. What relevancy it will have when this order of 5th July 2022 is challenged? What the order says, Lordships? It has only given current charge. Is it an appointment? Is it a promotion order? No appointment, no promotion. An interim order of 26 May 2022, which is at page 139, only talks about appointment and promotion only, nothing else. Therefore, when nobody was appointed, when nobody was promoted, the petitioner herself has made a mention that it is only a current charge. No appointment, no promotion, no benefit. Only a current charge was given. So, for not bringing to the knowledge of the Honorable Court about appointment and promotion shall be subject to the final outcome of the case. What relevancy it will have so as to decide Rule 18 when the interim order is only about temporary current charge. Therefore, entire case, entire application has been based on a misconceived ground. This is the ground and the reason given by the third single judge while vacating the interim order, that yes, this order was already there, but this was not brought to the notice of the court. And then so there is separation of material facts. So interim order was vacated. But my submission is, what relevancy will it have? Even if it is brought to the knowledge of the court, or even if it is not brought to the knowledge of the court. Because the issue in our case is about the interpretation of Rule 18, which talks about current charge. So only current charge was given by the speaker by order dated 5/7/2022. When no appointment was met, when no promotion was met, there is no question of bringing this to the notice of the court so as to decide the current charge. So where is the separation of material facts? Where is the relevancy?
Okay, Mr. Jamil, this is regarding suppression, suppression of which order? Passed in WPC 92,
Yes,
and you have filed 144,
yes,
challenging the charge, holding of charge.
yes,
Now, this order itself, 5th July, at page 95,
yes.
it also indicates subject to outcome of 92.
Yes. Subject to the final outcome of the case condition.
So,
Current charge.
this was before the court,
Yes,
isn't it?
it was before the court. So will it be relevant? Non-application of mine. And in the pleading also, can be seen.
No,
Page, paragraph 23.
relevant or irrelevant, whatever it may be, but there's a mention in the impugn order which you have challenged in 144,
Yes,
that there's one WPC 92.
yes,
So under the circumstance, can it be said or termed as suppression?
but that was the ground taken by the third single judge while vacating the interim order.
Okay.
And they come to page 42. The petitioner herself has mentioned in the petition about the pendency of this case.
Page
Page 42, paragraph 23, Lordships.
42.
And the issue in this case is only about current charge, nothing else. As your Lordships got it, paragraph 23, page 42.
Yes.
That the petitioner begs to state that the course of action to file the present petition arose due to granting of temporary officiating charge of secretary, administrative HOD, to the respondent number 2 on the ground of resignation by the person holding the post of secretary, and the method of recruiting to the said post as prescribed in the amended service code is subsidized before this honorable court in the WPC 92 of 2020. And no regular promotion has been done till date to the post of secretary. The petitioner is compelled to file this present writ petition owing to the uncertainty of the disposal of the proceeded petition, and it is pertinent issue to be decided by this honorable court as to who shall be eligible to hold the post of officiating charge of secretary during the pendency of the WPC 92 of 2022. The issue raised in this petition is not a subject matter to be decided in the WPC number 92 of 2022 and will have no pending on the pending litigation. That was also mentioned clearly. So, where is the question of suppressing any material facts? Even if it is not brought, what relevancy will it have? Well, it is only about current charge, not appointment, not promotion. And the interim order which I have referred to, which was passed on 26 May 2022, it talks about any appointment or promotion shall be subject to the final outcome of the case. And that fact was not brought to the notice of the court while moving the petition. That's how the interim order has been vacated on the ground of suppression of material facts. Whether it is brought or not brought, what relevancy it will have to decide the current charge and the Rule 18 of the rules.
Going by your own submission,
Okay.
if it's just basically a current charge,
Yes,
then why should the writ petition itself not be decided?
it should be decided.
Instead of, instead of hanging on the IA,
Yes,
interim vacation and all that.
yes. But lordships, unless I clarify this point, again, misconception will continue. That's why I'm trying to clarify. Otherwise, the best thing would be to decide the writ petition also, since it is pending. And it's been kept for a long time. And regular promotion should be considered. Why? What prevented them to appoint a person or to promote a person to hold the charge of secretary? Why they have not done for few months? It is all because of their temper. Now, my learned friend has submitted on roll 18 that the speaker has the plenary power to pass any kind of order. We are not questioning that, and I'm not questioning that. Speaker do not have the power. He has the power to issue orders for current charge. But that do not confer him the absolute right to violate the law. This honorable court, while disposing of the writ petition 323, there the observation made was on two grounds. If at all you want to review the gather, that may be done. Liberty is given to do that, which can only be done in accordance with law and in due consideration of all the stakeholders. That was the order. Taking advantage of that, they have amended the rules. Amendment will have challenge.
And successful, no appeal.
Yes, no appeal. Why no appeal was filed? For various reasons, but I need not say all these things. That order is still stands. Rule is valid. Even if rule is valid, the new amendment rule has not touched the eligibility criteria 2 years to be considered for promotion to the next higher post. Since the post has not been filled up by regular process, you were compelled to appoint one person to keep the current charge. And to decide the current charge, the argument was advanced that it is a selection post. It is to go as per the selection. Can you see rule 15 of the rules? What it says for promotion? How selection is to be done? She has been selected by a selection process under rule 15, which talks about the filling up the post by promotion and appointment. Procedure is laid down. She is just picked up by the speaker, not on the basis of a selection.
You're saying rule 15.
Rule 15 is the relevant rule. Departmental Promotion Committee. For all cases of recruitment by promotion, the selection there shall be promotion and selection. There shall be a departmental promotion committee. This is the normal procedure.
Now it's under which heading?
Under latest rule before amendment, that is second amendment. 2012 rules.
DPC.
Yes.
DPC.
Because selection is relevant only for normal promotion. And the 2 years requirement is there. Under the rules.
Where's the 2 years? Under which provision?
No, that is under new rule 7 B, page 91. page 91, second para Lordship, below the B. By promotion from the grade of additional secretary or equivalent in the assembly secretary with a minimum of 2 years continuous service in the grade, if deemed fit by the appointment of grade. So on the day of promotion, little more than 2 months, the private respondent was having the qualification, even going by the new amended rule, and even going by the submission of the consent for the respondent number 1, that she became eligible as per the amended rules, that is 18/5/2022, and on 5th of July 2022, she was given current charge. So the petitioner has challenged that what prevented the senior most officer to consider for a current charge. That is the case, which is challenged in the writ petition. And interim order was passed, interim order was vacated. That one is the suppression of material facts, and one is interpretation of any and senior most. My learned friend T.V. Jamir has also referred the judgment that if senior most is taken, then the word any renders redundant. That is the submission. So I respond to that. If any is given preference, then senior most will be rendered redundant. So it's not only senior most, the word most is there. Senior most. Then who is the most one? Senior most.
Senior most is singular.
Senior most, yes.
That's right.
And that time, the petitioner was the only person.
Any means more than one. Senior
Yes.
most means one.
Yes, but
So there's
they should
contradiction.
possess 2 years. As per the rule.
Okay.
They should possess 2 years to get promoted to the post of secretary. What compelled them to ignore that? The plenary power permits, the plenary power of the speaker permits to ignore the rule. That is my question. Whether the plenary power of the speaker allows and permits to ignore the rule and to just pick up a person from the street and then just be the secretary. What is the meaning of maintaining the rule of law? Rules have been ignored. Is it not purpose? By ignoring the rule, something has been done. What more perversity will be there beyond that? An irrelevant rule has been brought in and vacated the interim stay. In order to decide rule 18, rule 7 has been invoked. But there is a single judge.
Okay, I think that's it.
There are many, but let me just close. Only one line. Rule 15 is DPC is 14 secretary, because the motion mechanism rule 15 that determine the DPC secretary. So mother rule 15, the constitution of DPC under rule 15 is for three secretary, even if motion mechanism the rule 15, the constitution of DPC determine is the secretary. For promotion of secretary to additional secretary above is 12. Now, Lordship, another submission was made that it is only current charge. Only current charge. No benefit, nothing. Therefore, it should not be in effect. If you say that it is only current charge, no benefit, what compels the respondent to come before this court for vacating the interim stay if it is a current charge and there is no benefit? Because they are saying after vacating the interim order, it is only a current charge, no benefit, nothing, no promotion, same grade, same scale, pay scale, no benefit. So what is so great about it? You should have ignored. That is what the submission has been advanced. Then, what is the point for the private respondent to come before this court to vacate the interim stay?
There's only one
It is only current charge.
There's only one secretary.
Yes.
That's why.
And Lordship, one development. The interim order was passed on 26th of May 2022 in the writ petition, that is WPC 92 of 2022. That time, there was agitation going on. At the time of filing the BPC 92 of 2022, there was one principal secretary in the Assembly Secretary by name one Anthony, PG Anthony. He was the administrative head in the Assembly Secretary. But since he was appointed after retirement from Lok Sabha,
Overage.
yes, over age. So that was agitated by all the members in that movement. The private respondent, petitioner, and all the members of the associations were together. And then this PG Anthony, he submitted resignation on 22nd June 2022. Petition 92 was pending that time because interim order was passed on 26/5/2022. PG Anthony resigned. The administrative head resigned on 22/6/2022. After a few days, the respondent number one was appointed as was given current charge, not appointed, was given current charge on 5th July 2022. I have challenged that, saying that, look, I am the additional secretary since 2019, and the present private respondent who has been given the current charge is only about more than 2 months in, who can be considered for promotion to the higher post of secretary. Therefore, what compels the speaker to pick up respondent number one by ignoring the senior most officer, and the rule says that any of the senior most. So senior most should be given the preference to discharge the functions of the secretary. That is how the writ petition has been filed. And in view of the establishment of the prima facie case, the interim order was passed. Interim order was vacated on so many relevant grounds, which is under challenge in this rectification. And now, even after the writ petition, WPC 92 of 2022 was kept CAV, heard and concluded on 3rd February 2023. After 2 years, 2 months, 21 days, judgment was passed on 24th of April 2024. More than 1 year, judgment was not passed. And after passing the judgment on 24th April 2024, there was no interim order, no stay order, not to appoint a secretary on regular basis. There was no bar by this honorable court, but they have not filled up the post, no steps were taken. In spite of the fact that there is no stay order.
Case was reserved on which date?
3/2/2023. Say
Then it cannot be 2 years.
and that day, the order was passed that the WPC writ appeal shall be taken up after disposal of the writ petition. That is WPC 92 of 2022.
That's correct, but
Yes.
Mr. Jamil,
1 year, 2 months,
it's not 2
21
years.
days.
It's not 2 years. You said
It's
2
not
years.
2 years. Oh, I will throw that. It's 1 year, 2 months, 21 days.
So that's the reason why 144 could not be taken up.
But there was no stay order.
No, the writ petition 144 could not be taken up.
Yes, yes.
Because of the
Yes,
pendency of that
taking
case.
up the writ petition was because of that. Yes.
So you had to file this IA and all that, and
Yes.
all these things happened.
Motion placed in order in 155.
Mm.
On the submission of matter.
145.
In 144, there is an order on the submission of the friend order was passed, that 144 will be after the disposal of the writ petition. That is how.
In 144.
Yes.
Oh, that's why.
And with regard to the pleadings, by referring to the judgments, there is no pleading about the eligibility criteria. I have met in paragraph 18 of the writ petition, page 40 of the appeal memo, that the petitioner is eligible to be considered for promotion to the secretary. But submission was made that there is nothing in the pleading that she is eligible. So that is contrary to the reports.
144 is the mother.
Yes, I'm talking about 144. I'm not talking anything else more than 144. In view of time constraint, Lordship, I am not replying to my.
Fortunately. So we'll close the matter. We'll think about it and consider and pass.
Very patient in getting that. This thing appears to be a bit high for both the parties.
Please write, heard Mr. C.T. Jamil, Lanet, Senior Counsel,
And assisted by I.M. Chen.
assisted by Mr. I.M. Chen for the writ appellant, comma, Mr. Takamasa, Lanet Senior Counsel, assisted by Arun Long for the respondent number 1, and Mr. T.B. Jamil, Lanet Counsel for the respondent number 2. Parties have made their submissions. Hearing concluded, order reserved.
What?
Books. How many are there books to put not now? I think you better print it.
हाँ ना ना प्रिंट कॉपी दो हाँ
Single now. What's this?
प्रिंट कॉपी लगो साइटेशन करना है For judgment, item numbers 25 and 26.
This is a common judgment. The operative portion is that the meeting summoned by the respondent number 4, including the special session in the considered view of this court, cannot be considered as a show cause notice and an opportunity given to the petitioner to respond as to why he should not be removed from being chairman and a member of the village council. Then, upon considering the facts and circumstances of the case, court is of the considered view that there has been violation of the principles of natural justice, and as such, the impugned order dated so-and-so, removal order dated so-and-so, and the corrigendum cannot be sustained in law, and accordingly they are set aside. Since the impugned orders have been set aside for violation of the principles of natural justice, and therefore, notwithstanding the interference of the same by this court, respondent authorities are not debarred from proceeding against the petitioner in accordance with law. With the above observation and direction, writ petition stands disposed of.
Your Lordship, I wish to file an additional affidavit. I received the report from the Deputy Commissioner.
28.
Yes, item number 28. So if I may be allowed to file an additional affidavit to place on report the Deputy Commissioner's report.
How long? How soon? Ms. A. Aimi, Learned State Council, submits that she has received the Deputy Commissioner's report and therefore she may be allowed to file the same by way of an affidavit, and for which she seeks for 2 weeks' time. Prayer is allowed. Before that, you write, said prayer is not objected to by the other side. In view of above, list the matter again after 2 weeks. The state respondents to file the additional affidavit in the meantime. Yes,
Please hear, Roshi.
yes.
I beg to mention item 17 of the directives. In this case, Ms. Devika, advocate, she is on maternity relief. The matter is being listed since May, and because of her absence, the matter will not be taken up. So if the additional advocate general be directed to fill a file and then assign it to some other advocate.
Why should we direct them? Why don't you make the arrangement yourself? So going by what Mr. Tompok is saying, I think it's gonna take some time. So similar issues have been faced there in Aizawl bench also. 2 or 3 government advocates are on maternity leave. So they had to appoint additional government advocates, and I told them also, you make arrangements within yourself to take briefs. Mr. Tompok Pongen, our learned counsel, submits that the matter has been pending for quite some time for the inability on the part of the conducting government counsel to take up the matter. Mr. Im Song, under additional AG, submits that he will look into the matter and see that the brief is taken over by some other government counsel. And for which he prays that the matter be adjourned for 2 weeks. Okay, as prayed for, matter stands adjourned for 2 weeks.
And interim.
Interim order passed earlier shall continue till the next day.
Right.
Also did to mention, I don't know, 27. Also here, after the. I have to tell that one additional affidavit.
Yes, what happened?
Outside for waiting and not yet returned. So I will file with it.
Okay, Mr. Im Song, learned additional AG submits that he has sent the additional affidavit to be filed for vetting, but he's still yet to get the same back. He therefore prays that he might be granted a week's time to file the additional affidavit. Okay. And the state prayer is not objected to by the council for the opposite party. In view of above, list the matter again after a week. When? Now? Why not tomorrow?
The process is a directive, Lordship. Now what has happened was the state government has taken a decision to place me as OSD, Lordship, which is an executive post, Lordship. They also contemplating to take some actions, Lordship.
Have it tomorrow.
Lordship.
Two. Have we informed the other side?
Social counsel for petitioner on behalf of LRM.
Okay, any objection?
No, Lordship.
You're saying item 2. Huh?
Item 2, 1, 2.
2 of 1, 2 means? Oh, item 12. You want to mention it separately, 1, 2. Okay, on the prayer made by the Learned State Council, further 3 weeks' time is granted for filing counter affidavit. List again after 3 weeks.
Lordship, interim will continue.
Meanwhile, the interim order passed earlier shall continue till the next date.
Lordship, item 9 and 10.
Yes, anyone, have you informed the other side? No. Okay, as prayed for by the Learned State Council, who submit in a state council, further 3 weeks' time is granted for filing counter affidavit. List again after 3 weeks. This also counter affidavit. As paid for by the Learned State Council. We'll list the matter again after 3 weeks.
19-24. On behalf of this chapter. This is better after 2 weeks.
Other side? Okay, as paid for by the Alliance State Council and not objected to by the other side. These matters, THESE, these matters again after 3 weeks. 19 to 24.
I read to mention item number 16.
Yes,
I read this matter may be adjourned after for 2 weeks. I think the concern of the other one.
you're for the government
And for the petitioner.
or you're for the petitioner? Okay, on the prayer made by the learned counsel for the petitioner and not objected to by the other side, matter stands adjourned for 2 weeks.
Yes, Your Worship. Your Worship, I did mention for item number 18. Worship, kindly give us 3 weeks time to file our additional affidavit.
Additional affidavit,
Item number 13, Your Worship.
additional or reply?
No, additional affidavit. I got some relevant documents from my client, which is to be placed in record.
What are those documents?
It's part of the initial appointment, Your Worship. Initial appointment.
Any objection? Your good name?
Vikono Kiso, counsel for petitioner.
Miss Vikono Kiso, learned counsel for the petitioners, submits that there are certain documents which the petitioners would like to place on record for consideration of this court. And therefore, she prays that the petitioners may be allowed to bring the same on record by way of an additional affidavit. Stop. In view of above, when as prayed for,
3 weeks, Your Worship.
the matter stands adjourned. Will be listed again after 3 weeks. Petitioners may file the additional affidavit in the meantime. Okay.
I'd like to mention item number 3 to 8. He has still received by affidavit. So kindly grant me 3 weeks. Consent from the petitioners.
3?
3 to 8.
Oh, wholesale,
7 weeks, Your Worship. They're all-
whole scale, analogous, but they're not clubbed together, is it? How much time?
3 weeks, Your Worship.
As paid for which by Miss AIME, London State Council appearing for the state respondents. Further 3 weeks' time is granted for filing counter affidavit. List again after 3 weeks. 3 to 8. 3, 4, 5 separate order. 6, 7, 8 will be together perhaps.
For admission, item number 1.
Here for the petitioner. Yes. You have not filed your reply affidavit. Correct. So, I mean, you are given time to file reply affidavit.
Listed for 3 weeks.
Okay, it's paid for by the learned counsel. Appearing, your good name? As paid for by Miss Yuka Kokla, learned counsel. Appearing on behalf of Mr. Sentianga, counsel for the petitioner. Further 3 weeks' time is granted for filing reply affidavit. List again after 3 weeks.
For admission, item number 2.
On behalf of regional, under the dimension of the trees.
Okay, as paid for by the London State Council, further 3 weeks' time is granted for filing counter affidavit.
For admission, item number 11.
State is already filed the affidavit.
The petitioner has not filed reply affidavit. And therefore, further 2 weeks' time is granted for filing the same. List again after 2 weeks.
For admission, item number 14.
How much? No counter. As paid for by the Learned State Council, further 3 weeks' time is granted for filing counter affidavit.
For admission, item number 15.
The lordship here also state is it to file affidavit, so kindly penetrate.
The petition of all expired in the year 2019. Expired by resignation. It's more than 5 years. I guess it's There's an emergency to urgently issue to discourage the file affidavit. Next.
Ms. A. IME, Learned State Council, prays for further 3 weeks' time to file counter affidavit. Stop counsel for the petitioner submits that the matter relates to compassionate appointment on account of the death of the father,
Yes,
father of the petitioner. When?
2019.
In the year 2019. Stop, as such, there is some urgency in the matter. Stop, however, considering the fact that the writ petition has come up for the second time today, the court grants further 3 weeks' time to the respondents. Exhausted? Okay.